Just give me a thumbs up. Hi, well, welcome to Housing 101. Today we're going to have Tressa with Legal Aid of Oklahoma talk about fair housing. And if you're following along on Facebook, of course, you can ask questions and we'll address those as they come. All right, Tressa. And then there's your clicker. Okay. Is this your phone?
Everybody, can you hear me? Yes. Wonderful. Good morning. Good morning. Good morning. So my name is Teresa Webster. I am the Fair Housing Project Director for Legal Aid Services of Oklahoma, and I'm also a staff here. You cannot hear me. Okay. What about now? What about now? Nope. Okay. Now? Okay. We will make it work. So I am the Fair Housing Project Director for Legal Aid Services of Oklahoma, and I'm also a staff attorney there. I work with Eric Howlett, who will be coming after me. And today I'm going to share with everyone about fair housing. The Fair Housing Act does apply to other housing providers other than just landlords and property managers and their respective employers, but because we know that mostly landlords are attending, today I tailored the presentation to speak to rental opportunities and for rental providers. How many people here are landlords or work for some type of property management? Okay, anyone who, okay, so how many people are attorneys? Anybody connected with the housing industry? Okay. So everybody else is here for a different reason, that's okay, you get to learn this. So the first thing that I want to do is give credit to HUD. We are a HUD-funded private enforcement initiatives agency. We do other things as well, but our fair housing project is funded by HUD, and so they give us a grant to go out into the community to train the public about the fair housing laws. And so even though, as Kendra said, this may seem to be tailored to basically on what not to do. We just want to provide legal information about what the duties are under the Fair Housing Act so that nobody crosses that line. I know that some presenters who give information about the Fair Housing Act will give information on basically where the line is and how close you can get before you cross that line. This is not that type of presentation. So I would love to give you information about where the line is and just stay on the other side of it. Don't even get close to it. Okay, so that's what this is here for. So our goals for the presentation, we have three. First of all, I want to give basic information about the Fair Housing Act for rental opportunities. Secondly, I want to discuss with landlords the duties that arise under the Fair Housing Act. And then lastly, I would like to discuss some of the remedies that are available to individuals who have been harmed by discriminatory practices, and then the consequences that could flow from a violation or violations of the Act. Okay. So what is the Fair Housing Act? How many people know what the Fair Housing Act is, other than me and Eric? So the Fair Housing Act is the statement or the policy of the United States concerning equal housing opportunities. And I'm just going to read the actual language of the Act. It says, it is the policy of the United States to provide within constitutional limitations for fair housing throughout the United States. And so that's basically any of the contiguous states, any of the states that touch, any of our territories, Hawaii, Alaska. The Fair Housing Act applies in all of those areas. The Fair Housing Act makes housing discrimination illegal in the United States depending on the basis, because we have certain bases where you cannot discriminate against a person in a housing transaction or most residential real estate related transactions. And it has been the law since 1968, so for 51 years, this is not a new law, it has been illegal in the United States to discriminate against individuals in their housing-related transactions for the specific reasons that I mentioned within the presentation. So now I'm going to go over some important definitions. within the Fair Housing Act, that really applies to the rental, or in the rental context. First of all, a dwelling. You don't have fair housing violations where you don't have a dwelling involved. So there has to be a dwelling, and a dwelling is defined as any building, structure, or portion thereof which is occupied as or designed or intended for occupancy as a residence by one or more families, and any vacant land which is offered for sale or lease for the construction or location thereon of any such building, structure, or portion thereof. And that's directly from the Act. So it applies to buildings that are intended for residences, and also the land that they are sitting on or that they will sit on. Here are some examples of dwellings. This is not an exhaustive list, but these are some examples. So we have apartment units or the apartment complexes themselves, single-family homes in some circumstances. That's why I have the SAR. Mobile homes. A lot of people think that that there's an exception for mobile homes because they're mobile, but they are covered by the Fair Housing Act. A rented lot in a mobile home community, so it not only applies to the mobile home, but also the lot that it's sitting on. A room in a motel or a hotel that is rented as a residence versus if you're just renting it for a vacation. Dormitories are covered under the Fair Housing Act. Rooms that are rented in a person's house, depending on how many rooms are for rent and whether or not that person is using it as a business versus an ongoing business versus, just to make income if it's a smaller house. So there are some exceptions that apply, but I'm thinking that the people in this room would not fall under those exceptions. That's why I didn't include them. Okay, so here's another important definition: a person. Okay, when we think of a person, we think of like you and me, the people sitting next to you, right? Okay, well, it's more broadly defined under the Fair Housing Act, so a person can include an individual, a natural individual, but it also includes non-person entities like corporations, partnerships, trusts, LLCs, unincorporated. Okay, unincorporated entities. So you can have more than just, it's not just the people, but it can be the organizations that they work for. And I also want to add that person as defined under the Fair Housing Act not only applies to the people who are required to follow the Fair Housing Act, but it's also the people who could be harmed by a fair housing violation. So you can also have a non-person entity that is harmed because of a discriminatory action. We'll talk about that under consequences. Here's some examples of persons: leasing and or rental agents, property managers, obviously, right? Maintenance personnel, owners of rental housing, realtors, the real estate company itself, property management companies. The neighbors can be considered as persons who can either be who can be discriminated against or who can help violate the act. Advertising companies and or their agents. So we have like newspapers or publishers, social media sites, tenants, and then also associates of tenants can be considered as persons under the Fair Housing Act. Again, this is not an exhaustive list, but these are some examples. Here's another important definition: to rent. Okay, that's important, right? Because we're talking about rental, so we need to know what that means. So under the Fair Housing Act, to rent includes to lease, to sublease, or to let, and otherwise to rent for a consideration, the right to occupy a premises not owned by the occupant. That word consideration is important. That's why it's bolded, right? Because guess what the next thing is that we're going to define? Look at that, consideration. So in the state of Oklahoma, this is how consideration is defined. Basically, it is anything that is given in exchange by a promisee or promisor to another person for a benefit that they would otherwise not be entitled to. So in this case, we're talking about rent. Rent does not, consideration doesn't just have to be money. It could be services. It could be services. It could be maybe goods that are provided. The important thing is that consideration has to be legal. We do have some transactions that occur within a rental context. Nobody in this room, right, where a legal consideration is requested in exchange for housing. Nobody in this room does that, right? Right? Thank you. Not rhetorical. Nobody's doing it, but nobody's doing it. Okay, but we do have some transactions that occur under the Fair Housing Act where the legal consideration is considered. We'll talk about that later on in this presentation. And so a legal consideration voids the contract, but important thing to know is that rent is not just money. It could be goods or services or anything that is given in exchange, anything that's legal that's given in exchange for the housing opportunity. Here are some examples of consideration that are considered as satisfactory to satisfy the to rent definition of the Fair Housing Act. You can have federal funding or grants that are paid to a homeless shelter or other entity in exchange for shelter to be provided for residents. You can have a co-signer or guarantor's agreement that is given in exchange or on behalf of a renter. If that's accepted, that's consideration. An employee's payment of reduced rent. And that conjoined with their labor efforts or employment services could also be considered as consideration. If Eric goes over this part, you will see that may not be covered under the Landlord-Tenant Act, but it is covered under the Fair Housing Act. So the markets that are covered by the Fair Housing Act, meaning this is what the Fair Housing Act is intended to regulate: rental, obviously, sales, lending, advertising, insurance, public and private housing, and then also just most residential real estate related transactions are covered by the Fair Housing Act. So far as the rental area is concerned, it is much broader than the state Landlord-Tenant Act because it covers every part of the transaction. So the Fair Housing Act covers every part of the transaction, and you don't have to have a contract with a person to be required to not violate their fair housing rights. So here are examples of covered residential real estate related transactions. You can have requests for information about available rental housing. Again, there's no contract, they're just asking for information. Requests to inspect available units. Again, no contract. Leases and rental agreements. Your notices that you give out to your tenants about rental housing, or notices that are published in regard to rental housing. Those are covered by the Fair Housing Act. Your eviction proceedings and termination proceedings are covered by the Fair Housing Act. Any services that you provide in relation to the rental housing opportunity are covered by the Fair Housing Act, and your oral statements that you make as well as the written ones are covered by the Fair Housing Act. So your protected classes, these are the bases that you are not allowed, or that landlords are not allowed to discriminate against people for when they are considering them for housing opportunities. We have race, color, meaning the color of a person's skin, because you can have people of different races, but they also have different colors of their skin. And we have seen it, where we don't discriminate against everybody in race, but we just don't like people of a certain shade. That goes for every race. That's illegal. National origin, that has to do with where people come from or where they're perceived to have come from. Sex, right now for the Fair Housing Act, means male or female. Religion, familial status, and that applies to individuals who have children in their home that are under the age of 18 years old, and then also to expecting families, and then disability. And this is how the Fair Housing Act defines disability. Now, the law was written in 1868, so they weren't as progressive as we are now. They were using the word handicap back then, but now we are using the word disability. It means the same thing. A handicap or disability means, with respect to a person, a physical or mental impairment which substantially limits one or more of such person's major life activities. It is also a record that indicates that such an impairment existed, or if the person is regarded or perceived as having an impairment. That falls under number one. It excludes the current use of substances, and it also does not include, it excludes the illegal use of addiction or addiction to controlled substances. And I believe that there's also a provision that talks about how it doesn't apply to individuals who are transvestites, and so that there are laws involving, so, okay, but not here. So here are some examples of major life activities. These are things that we would expect anybody to be able to do. So seeing, working, caring for oneself, someone's ability to sleep or walk, breathing or thinking, and this is not an exhaustive list. These are just some examples of things that people would normally be able to do, or these are major life activities that people will be required to do. So if they have a condition that impairs their ability to engage in any one of these things, they would be considered as disabled under the Fair Housing Act. And here are some examples of disabilities. I'll always include this because a lot of people think, well, you know, they look like they're okay. We We get that all the time when we're making requests for reasonable accommodations for individuals under the Fair Housing Act. The landlords will usually say, well, they don't look disabled. Well, you don't have to look disabled to have protection under the Fair Housing Act. These are some disabilities, just examples, not an exhaustive list, but like Alzheimer's disease. Like none of us have X-ray vision, right? So you can't see into, no, yes, no, two people, yay. So everybody else has superpowers in this room. But for the rest of us, I don't have X-ray vision, I don't even have 20/20 vision, can't look into a person's brain and see what's going on. It's an invisible disability, right? So, but it's still a disability. Alzheimer's disease, persons who are recovering from substance abuse. Like we said before, current use is not covered, but recovery is. So if a person's recovering from substance abuse addictions, they are considered as disabled for fair housing purposes. Persons with brain disorders, we have persons with mobility impairments, and you can see that, right? You can see if a person's using a wheelchair, cane, or a walker, pretty easily apparent, okay? And then also persons with visual impairments, and sometimes you can't see, but you can sort of kind of tell they have a CNI dog or a cane, you know, they probably can't see, right? So disability can be invisible to the naked eye, or it can be visible, but these are just some examples. When considering your Fair Housing Act obligations as a landlord, you also want to be mindful of other laws that come into play or other controlling provisions. So we have the Oklahoma Discrimination in Housing Act, which is our state fair housing laws. You want to know what those are. It's found at Title 25, Section 1451, and beyond for the Oklahoma statute. You want to familiarize yourself with that. Also, your city ordinances and municipal codes. You want to be aware of those because most cities have written within their ordinances some type of Fair Housing Act protection for the people who live there. You want to be aware of those. If you provide housing that is funded by some type of government funds, or you have a loan or a mortgage for the government, you want to be aware of the regulations that affect that agreement, and then also any official statements that have been issued by HUD or the agency that funds you. And the reason why is because you can have additional responsibilities under any of these situations. For example, in the state of Oklahoma, we have an additional protected class of age. So people who are over the age of 18 years old have protection on the basis of their age from housing discrimination. It is not a federal law requirement, but it is one that arises under the state. You need to know that. City of Tulsa has additional protected classes, including ancestry, marital status, gender identity, and sexual orientation. Those are not under the Fair Housing Act for federal purposes, but it is a city requirement. You may have additional or expanded definitions and duties also if you're in federal programs. So you may have an additional duty for limited English proficiency requirements that will require you to provide documents in certain languages and to make certain assistance available to people who don't speak English. If you live in, if your housing is located in an area where there are people who are known to speak other languages, and you have a predominant language other than English. So you need to be aware of those. And then also be aware of whatever your corporate statements and policies are about fair housing, because sometimes your corporate policies can require you to do more than what the Fair Housing Act requires to ensure that people are not discriminated against. And in this first place, I'm going to look, probably Eric as well, we're going to look at your lease, we're going to look at your corporate policies to see if you are treating people differently than what you have committed on paper to do, or to see if it's deficient. So you want to know what those are. So these are duties for landlords under the Fair Housing Act. Before I proceed to the next section, do we have any questions? Yes.
You may mention, like, when you look at the lease or the corporate policies or what have you, so say you have a lease that's typed up, and say I have a page that I have wrote down certain criteria on the back, and I sign and date it, when the tenant signs and dates it, is that legally permissible, or does it need to be all typed up and, extremely professional?
No, I mean, I'm gonna look at what you have written down, okay? But I'm looking at the agreement that you've made with, if I'm contacting you this because I have a client that's claiming that you've done something that you're not supposed to do, so I'm gonna look at whatever you gave my client.
Okay.
Okay? So I don't care if it's written up, I mean, as long as I can read it,
Letter.
you know, yeah.
Okay.
So, yeah. Okay, so, any other questions from Barbara? Okay, So landlords do these under the Fair Housing Act, what not to do, and I will tell you that I went directly from the statute. So you're gonna get a bunch of statutes in here, but we have examples as well, so that everybody will know what you're supposed to do. There won't be any questions. So the first thing we have are unlawful refusals to rent. So under the Fair Housing Act, it shall be unlawful to refuse to rent after making a bona fide offer or to refuse to negotiate for the rental of or otherwise make unavailable or deny a dwelling to any person. Everybody say that with me, any person. Okay, that was unscared. Any person. Thank you. Okay. Because of race, color, religion, sex, familial status, or national origin. I'm gonna ask a question. I have no gold stars today though. What class is missing from here? Which protected class? I'm sorry, which protected class is missing from here? You know, I probably need to walk around. Can I just? No, I can't. I cannot. Protected class. Somebody said it.
Disability.
Disability, that's right. Doesn't mean that you can discriminate against people, it just means that there's another section that deals with it. But the important thing here is any person, okay? So notice that it doesn't say tenant, it doesn't say renter, it doesn't say occupant, it says any person. What does that mean? Any person, all right, yes, okay. So here are examples of conduct that violates the Fair Housing Act, Section 3604A. If you have a landlord who refuses to negotiate for rent on an available unit to a couple because they... I'm sorry, that side, if I could come over there, I would. Can y'all feel the love from over here? We'll just sit there, okay. All right, yes.
You might try that other mic too.
Okay.
Maybe do both of them at the same time. Try it. Let's just see if there's crazy feedback.
Apparently, I have problems speaking loud. How about this one? Can y'all hear me? No?
Oh, turn it on at the very top. Maybe.
What about now? Nope.
No.
It was on, actually. Okay, that's okay. I will talk louder. How about that?
Okay.
I will try my hardest. I've been told that I don't speak very loudly. I'm sorry, y'all. But okay, so I was back to my examples then. Okay, so refusal to negotiate to rent an available unit to a couple because they are mixed race. That's an example of race-based discrimination. You have a landlord that terminates a tenancy for a couple after learning that they are expecting twins. You have an expecting family and housing is made unavailable to them because of the children that are coming. That is familial status-based discrimination. So those are examples of violations of 3604A. Okay, 3604B, it shall be unlawful to discriminate against any person in the terms, conditions, or privileges of rental of a dwelling, the provision of services or facilities in connection therewith because of race, color, religion, sex, familial status, or national origin. Again, we have no disability here, but have no fear, it is coming. Okay. So here are examples that violate Section 3604B. You have a landlord that requires families with minor children to pay higher security deposits than residents without minor children. Okay, clear violation, right? Different terms and conditions. A landlord who only enforces criminal background bans for non-white applicants, right? Clear violation. A landlord who informs English-speaking tenants about upcoming inspections 1 week before the inspection, while everybody else gets only 1 day notice, right? I mean, under the Oklahoma Residential Landlord and Tenant Act, you're only required to give notice of 1 day, right? But if you have different terms and conditions or services that are provided on the basis of here it would be national origin, that's a violation of the Fair Housing Act. Okay, 3604C, discriminatory notices, statements, and advertisements. It shall be unlawful to make, print, or publish, or cause to be made, printed, or published any notice, statement, or advertisement with respect to rental of a dwelling that indicates any preference, limitation, or discrimination based on race, color, religion, sex, handicap, familial status, or national origin, or an intention to make any such preference, limitation, or discrimination. The important thing about this is that, under state law, and I'm not gonna talk about the ORLTA anymore because that's Eric's presentation, but your notices have to be in writing. The Fair Housing Act does not require a written notice. A statement is good enough. You can have a verbal statement that violates the act, okay? So, it doesn't just have to be in writing. And you can make it, or you can give it to someone else to make. You can tell someone else to communicate a message, and you will still be liable, and so will the person who makes it. So here are some examples of conduct that violates section 3604C. A notice that reads no pet, no exceptions. No pets, no exceptions. Why would that be a violation? Disability. Y'all are smart.
Yeah.
Yes. Okay. An advertisement that reads quiet apartment community seeks mature persons for rental opportunity. Maybe familial status. Yeah, it would be age, definitely. But then what about familial status? Mature means we don't want any kids here, right? Okay. The verbal statement, your people always cause problems. I don't even have to explain that, right? Okay. What about this? A lease termination notice to a disabled person who relies upon an assistance animal that instructs the person to get herself, her dog, and all of her personal property out of the unit in 30 days or face eviction. We understand that that's a violation, right? I put it in there because it really happened. Yep, I saw it. I said that is low-hanging fruit, and anyway, so yeah. Okay, so 3604D, false representations about the availability of a unit for inspection or rental. It shall be unlawful to represent to any person because of race, color, religion, sex, handicap, familial status, or national origin that any dwelling is not available for inspection or rental when such dwelling is in fact so available. An example of this violation, we have a white prospective tenant who calls to find out if any units are available for inspection. She comes to the complex to inspect the unit with her black husband. The leasing agent tells them that no units are available for inspection, even though there are units that are available. We understand why that's a violation, right? Okay, how are my people on the other side doing? Can y'all hear me? I'm doing good? Yes, ma'am. Because of dogs, that's exactly right. And the case that involves, which I'll talk about a little bit later, but the whole issue, the reason why housing was made unavailable to her was because she made a request for reasonable accommodation to not have to pay pet rent because she had a dog that was an emotional support animal. And so the landlord got mad and said, you have 30 days to get yourself and your dog and all your property off of this, or I'm going to evict you. So, yes.
That's like, I guess, add on to that, so with the animal, if they need the animal as an assistance animal, what have you, if the animal is destructive to the property, what about it? They kind of listen, say you need to go because your dog is tearing the house out.
Yeah, well, that's okay, that's a good question. I'm gonna get to reasonable accommodations in a minute, but you know what? I'm not gonna leave you hanging because I may forget. So I'm gonna answer that question right now. So the thing of it is that a landlord can grant a reasonable accommodation for an assistance animal to be in a unit, but the tenant still has a duty to follow all of the other rules that pertain to animals. So if you have a rule that says you have to control your animal, and the Fair Housing Act and has statements concerning assistance animals even address that. If the animal is destructive and not being controlled, then the landlord has a remedy, which is basically tell the person, look, either you fix the problem or I'm gonna have to, either terminate your lease or you'll have to get rid of the dog or whatever. But the landlord is not required to allow the animal to be, Cujo, eating everybody up and destroying the property. The landlord has a remedy. They can tell the tenant you're not controlling the dog, so you need to, or your animal, so you need to either control it or get rid of it. Not a violation. Okay. Where was that? So, section 3604E, it shall be unlawful for profit to induce or attempt to induce any person to rent any dwelling by representations regarding the entry or prospective entry into the neighborhood of a person or persons of a particular race, color, religion, sex, handicap, familial status, or national origin. We saw this a lot in the 60s when, well, I didn't see it because I was not here, probably not listening to it, but it was really big thing in the sixties where you had individuals who were, basically for-profit, capitalizing off of things like white flight and stuff like that. And, you know, we were trying to integrate neighborhoods, and so they would sell the home to a person who was not either the national origin or color of a particular, I mean, they broke up the monochromaticness, that's not really a word, I just made one, of the neighborhood. And so after, you know, breaking up the color scheme of the neighborhood, they basically would induce individuals to sell their homes so that, you know, because of who's entering the neighborhood. We see that now with things like group homes. If a group home is entering the neighborhood, you know, it's illegal for someone to induce people to sell their housing or to leave the neighborhood because of the person group home is entering, because that's a disability-related transaction. Also, you can see it when multifamily housing complexes are entering a neighborhood. People may be induced to sell for that reason. That still violates 3604E. I didn't put an example on the slide, but that's an example. So now, what everybody has been waiting for are disability-related provisions. Everybody's happy, right? One person. Okay, I'm happy too. We're together. Okay, so these are our disability-related provisions. The reason why they weren't included in previous sections is because they weren't added to the Fair Housing Act until 1988. I guess Congress could have amended, but they decided to put them down here, so we'll talk about them. First of all, it shall be unlawful to discriminate in the rental or to otherwise make unavailable or deny a dwelling to any renter. Now, this is not any person, right? Any renter, because of the handicap of that renter, a person residing or intending to reside in that dwelling after it is so rented or made available, or any person associated with that renter. This is different from the earlier provisions because you have to have at least a prospective renter. So a person who is seeking a housing opportunity or rental housing opportunity who's denied a housing opportunity because they are disabled or because they're going to have people who are disabled living with them or because they're associated with persons with disabilities. So that gets you, that's your 3604F1. Here's an example. Refusing to rent an available unit to a person because the person's spouse died of an HIV-related complication, right? Here, the person who is seeking the rental opportunity is not disabled, him or herself, but because of the fact, oh, can you advance the slide, please, Kendra? She's asking you to advance the slide. I think she's asking for the slide to be advanced. Are we good? Okay. Thank you, Kendra. Okay, so here the person who's asking for the rental opportunity has not, they don't have a disability, but they were associated with someone who did. And so the housing opportunity was denied. And so that would be a violation of 3604F1. 3604F2, it shall be unlawful to discriminate against any person, where any person, again, here you don't have to be a renter, in the terms, conditions, or privileges of rental of a dwelling or in the provision of services or facilities in connection with such dwelling because of the handicap of that person or a person who is residing in or intending to reside in that dwelling after it is so rented or made available, or a person who is associated with that person. So again, there's an any person requirement. So any person who is discriminated against because of their association with a person with a disability can, or because there is different terms and conditions applied to them because of their connection with the person with a disability or their own disability, would be able to file under this act. You have a question, ma'am?
What if they're in a wheelchair and the dwelling is not handicap accessible? So how would that fit in terms, you're not discriminating against, but you don't, as a landlord, I can't afford to make it handicap accessible.
Right. So, but you don't have, but don't get the housing unavailable to them. See, and we'll get to that in a minute.
Okay.
So y'all are lovely strength of consciousness here. So y'all are thinking. So, but yeah, a unit doesn't have to be handicap accessible for a person with a disability to live there. So that's the short answer to your question, and we'll get to what to do in those situations, okay? Okay, so here's an example of conduct that violates section 3604F2, a policy that requires people who use motorized wheelchairs to pay a larger security deposit than people who do not use wheelchairs. We have seen it, that's why it's up here. That policy violates the Fair Housing Act because it is a difference in terms and conditions because of disability. 204F3A. This is your question, so see what you're thinking. This has to do with reasonable modifications for persons with disabilities. So discrimination includes a refusal to permit at the expense of the handicapped person reasonable modifications of existing premises occupied or to be occupied by such person if such modifications may be necessary to afford such person the full enjoyment of the premises, except that in the case of rental, the landlord may, where it is reasonable to do so, condition permission for a modification on the renter agreeing to restore the interior of the premises to the condition that existed before the modification, reasonable wear and tear accepted. So to cover your question now, first of all, it's going to depend on when that unit was built. Okay, we'll get to the design and construction requirements under the Fair Housing Act, I think in probably a couple of slides. But if the unit that the person is seeking to rent was built before March 13, 91. Okay, 91. If it was built before March 13, 1991, if it has not been renovated after that time period, then the person can make a request for a reasonable modification. The person with the disability or the person who is the person with the disability has to bear the expense of making that modification or making the modifications to the unit to make it accessible. So cost is not a factor, even if it's not handicap accessible. If they need to have some accessibility requirements or have some things moved around, they can request to make modifications. And the modification is a change to the structure of the actual rental unit. So that could include, and I'll get to some examples in a minute, but in federally funded properties like public housing, the landlord bears the expense. If you're not a federally funded landlord, then that person who is making the request will bear the expense. Again, the landlord can reasonably require the restoration of the interior of the unit as a condition of air permission. And I just mentioned that with the act, there has to be a connection between the disability-related need and the request for the reasonable modification. For example, just because I have a hearing impairment, I cannot ask you to let me modify my unit to the swimming pool in my unit unless there's a disability-related need. Probably not, right? So there has to be a connection between what the person's disability is and the need that they are requesting, the modification that they're requesting. The landlord can request verification of the disability and the need for the requested modification if the disability is not readily apparent. So going back to my example with the hearing impairment in the swimming pool, I need to know why you need that real. Can you give me reliable verification? And that can be from anyone who has intimate knowledge of the person's disability and their disability-related need. It doesn't just have to come from a doctor. The landlord may require that the modification be made in a workmanlike manner, meaning that you can require permits, you can require that they have a profession. You can't tell them who to go to unless they ask, but you can't tell them you have to use this specific person, but you can, as a landlord, require that they make the modification in a workmanlike manner because you do want your tenant to be safe, right? If they install a ramp, you don't want them or other people falling off of it and hurt themselves worse. And then the landlord can also require that the tenant place money in an escrow account to pay for the restoration of the interior. So depending on how long that person is planning to be there, maybe you can work out an agreement where they can pay so much into an account so that when they leave, you can, restore it to the way that it was on the inside. Yes, ma'am.
Are there other disabilities other than a wheelchair? Like a wheelchair is obvious. Can a landlord use other disabilities in order for these modifications that the tenant would be responsible for?
Well, if the tenant requested, for example, we had one tenant, we know of a case where there was an individual who had COPD, and so they didn't use a wheelchair, but they needed a ramp and they needed certain modifications because of their COPD condition. I'm gonna get that right today. And so they requested modification because of that, and they were able to verify that disability, and as a result of that verification, they were allowed to have a ramp put in for that. So yeah, there are other disabilities other than mobility-related disabilities, yes.
Okay, so the tenant was paid for it if they verified that they needed it or disabled or what have you. You made mention of if the housing is federally funded. I have houses with tenants that are on OFA or THA. You said that I would have to pay for the changes to the structure?
Right, so I'm not talking about like a private landlord who accepts a subsidy. I'm talking about like public housing, things like that.
Okay.
Yes.
Okay, I apartment complex. And we'll take something as a screen door on the terrace, or porch, whatever you call it. If you moved into that apartment and that was supposed to be there, but it wasn't there, and you are on housing, I'm trying to understand why would housing have to pay for something that should have been there and it isn't?
And that's what, now, that's not a reasonable modification. You're talking about repairs and things that the landlord is supposed to provide. That's outside of the Fair Housing Act. What we're talking about are things that are necessary for an individual with a disability to be able to fully use the premises. So for example, if the person has a bathroom that doesn't have grab bars or that doesn't have rails, they need to add those, that would be something that they would have to pay for unless you're in a federally funded property. Then the federally funded property, the landlord would pay for that. So that's what we're talking about. We're not talking about things that every tenant should have that they're not providing. That's
Well, I'm asking you because as a tenant and disabled, there's a lot of things that should be there that are not, and that should have been there. So I'm trying to figure out where I stand because the statement was made to me, if housing pays for it, I don't see why housing has to pay for something that should have been there.
Okay, so let's you and I address that afterwards, because I think that that's probably more like falling under the landlord tenant versus disability related, so that would be outside the scope of this presentation, so you can address it afterwards, okay? All right, so how am I doing on time? I got like 10 minutes, right? About 10-ish, okay. Ooh, okay, so anyway, okay, so these are your reasonable modification. Here are some examples. The request to widen the doorway, you always see that for a person with a disability. Request to add ramps, as I mentioned before, grab bars for the bathrooms, also to lower cabinets or to remove them. Those are examples. And then the request can be made verbally or in writing. I know some places they say you have to fill out our form. No, you don't. It can be made in writing or it may be made verbally, as long as the landlord knows that the tenant has this need, it's been communicated the duty triggers. Okay. Okay, so 3604F, refusal to grant reasonable accommodations. Discrimination includes a refusal to make reasonable accommodations in rules, policies, practices, or services when such accommodations may be necessary to afford such a person an equal opportunity to use and enjoy the dwelling. So now we are moving from structural changes to changes in rules, policies, procedures, practices, things of that effect. For a reasonable accommodation, again, like with a reasonable modification, there has to be a connection or a nexus between the disability-related need and the person's disability. The landlord or the housing provider bears the expense of granting a reasonable accommodation because usually it's very minimal because it doesn't really cost a lot of money to change a room, right? The housing provider also must grant the reasonable accommodation unless it will result in an undue financial or administrative burden or will result in a fundamental alteration in the nature of the program or services provided by the housing provider, in which case if you cannot grant it, then you go down to the bottom. You have to engage in an interactive process, so you can't just say no. You have to say, let's see what we can work out. You know, if we can't grant this one, let's see what else we can do for you. And the landlord can also request verification again for the disability and the disability-related need if the disability is not readily apparent. So here are some examples of reasonable accommodation requests. A request for an exception to a no pet policy to have an assistance animal. Again, it's just changing the rule. A request for an exception to a pet deposit and pet rent policy for a waiver for a person who relies upon an assistance animal. Here's another one. A request for a designated parking space when the landlord has a policy to not have assigned parking. So again, it's just a change to a rule, right? It costs any money. The next one, 3604F3C, this is the design, these are the design and construction requirements, and that goes back to your question. Our lady on the first row, I don't know your name, I'm sorry. So again, for any property that is a multi-family, I won't say any, but it has to be multi-family housing, where that is designed or constructed after March 13th, 1991. It has to be accessible for persons with disabilities. I put this here, this slide here, mainly because a lot of properties in the city of Tulsa were built before that time, but this applies to renovations as well. So if you are renovating property after the date, which will be March 13th, 1991, it has to comply with these requirements. So it includes where you place your environmental controls, your light switches, the width of doorways, your accessible path into and through the unit. You have to have turnaround space for wheelchairs. So all of that falls under this. So you want to ensure, even if it's not a handicapped accessible unit, if there's a renovation, it has to fall. Any renovations fall under here. And then 3617, retaliation. So it says interference, coercion, or intimidation. It shall be unlawful to coerce, intimidate, threaten, or interfere with any person in the exercise or enjoyment of, or on account of his or her having exercised or enjoyed, or on account of his having aided or encouraged another person, or any other person in the exercise or enjoyment of any right granted or protected by those sections of the act. So basically, the person makes a request for a reasonable accommodation, you can't turn around and grant the accommodation and then retaliate against them and terminate their tenancy. So these are some examples. Landlord terminates the tenant's lease because the tenant requests a reasonable accommodation, or a landlord refuses to renew a tenant's lease because the tenant complains about discriminatory conduct. Those are violations of section 3617, and they are expensive, as we will talk about later on. So nobody wants to do that. Okay, so our individual remedies and landlord consequences for violations of the Fair Housing Act. First of all, who can bring an action? Aggrieved persons may request relief, and this is how the Fair Housing Act defines an aggrieved person. It includes any person who claims to have been injured by a discriminatory housing practice or believes that such person will be injured by a discriminatory housing practice that is about to occur. And an aggrieved person doesn't just have to be a tenant. So examples of aggrieved persons, again, prospective renter who's denied a housing opportunity. You can have a current tenant who is experiencing discrimination, a city or municipality whose residents are harmed by discriminatory practices of a landlord. A former tenant who has been harmed by discriminatory practice. You can have an organization like Legal Aid that can file fair housing lawsuits on behalf of our people who we represent if they are being harmed by discriminatory practice, and that comes out of our testing program. So the important thing is to remember, and I said it before, that the Fair Housing Act applies to every part of the rental transaction. You don't have to have a contract with the person to be liable for a Fair Housing Act violation, so just be aware of that. This is how an aggrieved party can obtain relief. They can either file a complaint with HUD. They have 1 year from the date of the last act of discrimination. They can also file a lawsuit in federal court or state court, because you can sue for federal fair housing violations in either jurisdiction. If the person files a complaint with HUD within the 1 year statute of limitations, and their statute of limitations for filing a lawsuit, it stops, the clock stops ticking when they file that complaint. And so HUD takes sometimes a while to investigate these complaints. So you can have a complaint that has been filed 3 or 4 years ago, and then they find reasonable cause. If they do, then the person can still bring their lawsuit if they don't settle. These are the individuals who can be sued for violation of the Fair Housing Act. The owner of the property, the landlord, a property management company can be sued. The individual agents of the landlord, any person who took part in discrimination. Here are your remedies that are provided under the Fair Housing Act. The person can get actual damages, which are their out-of-pocket costs for, or not just out-of-pocket costs, any damage that they suffer as a result of the violation. Punitive damages, which are damages that are given by a court to punish the wrongdoer. There can be injunctive relief, and that can be permanent injunctions or temporary injunctions. Civil penalties that can be assessed if there's an administrative action that is brought. Also relief that is granted for the benefit of the public. And basically the state of authority by the Fair Housing Act, or that Congress has allocated to courts, is to grant whatever relief is necessary to stop the discrimination from happening. So the court has broad discretion. What happens if HUD doesn't find reasonable cause, and basically there is a complaint that's filed and HUD says we don't see where discrimination occurred, it doesn't mean that the case goes away. The aggrieved party could do nothing, or they could still file a lawsuit in federal or state court, and the landlord then would possibly have to pay attorney's fees, and those are not cheap. Okay, so if the court finds no discrimination, the person can just drop the case, or they can appeal it because they can say the lower court was wrong, and sometimes courts don't always get it right. So if they appeal it, then the appellate court can affirm it, they can reverse it and vacate the lower court's decision and order a new trial, which means more money, right? Change. You don't want that happening. And the landlord would still be responsible in some cases for his own costs and attorney's fees. If there's a finding of reasonable cause and HUD finds that there was a discriminatory practice that occurred, they can give that party the opportunity to voluntarily stop engaging in discrimination. So that would be a voluntary compliance agreement, and then order, work out some type of relief for the agreed party. The agreed person still has a right of his own or her own to file their own lawsuit in court, and if they elect not to do that, then HUD can refer it to an administrative law judge. And if the administrative law judge finds that discrimination in fact did occur, these are the penalties for violations. $10,000 for the first violation. If another violation occurs within a 5-year period after that person has already been found to be a violation, $25,000 is assessed for the next, and then if within a 7-year period, they do it again, $50,000 will be assessed as a civil penalty, and all these are civil penalties that are paid on top of any actual damages that are suffered by the person who is experiencing discrimination, and the court can still order injunctive relief. And this is just an administrative law judge. This is not an actual like federal or state court proceeding. For natural individuals, if you have a person who continues to violate an actual person that's violating the Fair Housing Act, and those statute of those periods, 7-year, 5-year, they don't apply. They can assess those penalties under B and C without regard to how many years have passed. If an agreed person files a lawsuit in court, they could actually settle the action within the litigation, or they have the option of litigating it to verdict. They can file more than one claim. So let's just say that if there's a violation of the Fair Housing Act, if there are other laws that were violated, they can also seek remedies, seek relief for those other violations. And again, the Fair Housing Act vests a court with very broad discretion. So we want to stop the discriminatory action, and so there can be, they can assess injunctive relief and also punitive damages. So here are some examples of cases that we have seen, and I'm almost done. Twitty v. Belmont, that was a case that we had that we filed in 2017 that was litigated. I think we got a verdict in 2018. Where there was retaliation involved that violated the Fair Housing Act. A jury awarded the plaintiff $100,000, and there was approximately $99,000. I think it was actually more than $99,000. Am I right? Okay. I actually looked at your presentation and changed it, so I couldn't cheat. But anyway, $99,000 plus in attorney's fees. And so the case settled on appeal confidentially, but that landlord had to pay the city's attorney's fees, the judgment, and their own attorney. Trinity v. Nelden, that was the case I was talking about with the dog notice. That case was a denial of reasonable accommodation and retaliation, and the defendant confessed judgment for $35,000. Hearn v. Van Trails, I did say that right. Van Trails, right? Okay, that was Eric's case. Just had it. It's not even cold. It was a denial of a reasonable accommodation, also retaliation, any more claims. Resulted in a $20,000 verdict for the Fair Housing Act violation and $50,000 in punitive damages, as well as attorney fees, which are yet to be determined. This case was not our case, but this was a case out of Oklahoma City with one of our community partner fair housing organizations, where there was sex-based discrimination. That's illegal consideration, y'all. Okay, so anyway, sex-based discrimination, it resulted in a consent decree of $800,000 to the aggrieved individuals. The landlord can no longer work in the housing industry, and I believe that there are other proceedings that are still going on. So we have other cases that were filed, settled confidentially between 2017 and 2018, ranges of $10,000 to $40,000, as well as property awards and public interest relief. So the point is, it costs a lot of money to violate this law, so we just don't want to do that. So the conclusion, the Fair Housing Act applies to every part of the rental transaction, not just between renters and landlords. So just be aware of that. The landlord has to follow the Fair Housing Act, even if the landlord does not have a contract with the prospective renter. And lastly, it is expensive to violate the Fair Housing Act, so we just don't want to do that. So I am done. Thank you for your attention.
We do have a couple of minutes for questions.
spoke about the, fair housing HUD, federal, and then the landlord tenant, that's two different things. So, which one supersedes the other, or it's just separate?
They are separate and they work concurrently. Now, I'm not gonna talk about the landlord tenant act because Eric is coming and I'm not stealing his thunder, but, they work concurrently, usually, but the thing of it is this, the Fair Housing Act is more expensive. So, it's broader than the landlord tenant act, because the landlord tenant act is only going to apply where there is a landlord and tenant. The Fair Housing Act will apply even if you don't have that relationship, so it's broader. I want to tell everybody, if you want more information about like reasonable accommodations, reasonable modifications in your design and construction requirements, as well as assistance animals, go to HUD.gov. They have a search feature. They have statements, official statements that they have issued about reasonable accommodations, assistance animals, and landlord's duties. They're under reasonable modifications, and even design and construction requirements. You want to read those. I mean, they're pretty long, but they have like the question answer, frequently asked questions and answers, so it'll help you in shaping your policies. Any other questions?
What was that website again?
HUD.gov.
HUD.gov.
Yes, ma'am. Do you have a question?
Yes, and so under the ADA, for a service dog, as far as I'm aware, you're only allowed to ask 2 questions. Does that apply to landlords as well?
Okay, so the ADA is different, and the ADA does not apply throughout the entire complex, and so, yeah, it would apply to landlords as well, but really, the Fair Housing Act is going to cover every area of your apartment complex versus the ADA, which really only applies to the public areas, which would be like your leasing office, maybe your parking lot. So, and
So when a landlord and a tenant, possible tenants, are engaging in a conversation about anything in the work, when a landlord and a potential tenant start engaging in a conversation about renting that apartment, is the landlord limited to only asking those 2 questions that the ADA allows about a service dog?
so the ADA really is not what's going to govern. Now, HUD.gov, again, they have a statement that basically explains the overlap between the Fair Housing Act, the American with Disabilities Act, and Section 504 of the Rehabilitation Act, because they all have they have overlapping duties. When a landlord and a tenant are negotiating for the rental of a unit, you want to know what your Fair Housing Act requirements are, what your duties are under the Fair Housing Act, because that's what's going to cover it, okay? Unless the tenant is going to live in your leasing office, your Fair Housing Act is what's going to apply. And you are not limited. First of all, the Fair Housing Act is more expensive also when it comes to animals, because the ADA only applies to service dogs and miniature horses. Okay. The Fair Housing Act does not define what an assistance animal is. It can be more than just a dog. We use the dog example because that's the most common one, but people have had emotional support monkeys. They've had pigs. We had a mini pig case in Oklahoma, in a city that was a suburb of Oklahoma City, where our client needed to use a mini pig, so it's a miniature pig. So it can be a miniature pig, it can be a rabbit, they're with a reason. So your ADA provisions aren't really going to apply to a tenant's request for a reasonable accommodation to have an assistance animal in her or his unit. You're looking at your Fair Housing Act obligations, which are broader, so you want to know what those are. Okay?
Thank you.
You're welcome. Yes, ma'am.
So if it seems to me that the fair housing is really directed for landlords and what they can and can't do, is there something similar for tenants, what they can and cannot do?
Okay, so that's a good question. And so as Kendra said, so she made the disclaimer, and I had actually built it into my presentation to say that tenants do have responsibilities under the Fair Housing Act. I've cited to you the landlord portions because typically that's what we have here. accommodations because the majority of our audience are landlords or housing providers in some capacity. But your lease really is going to tell you what the tenant can or cannot do. Also, your landlord and tenant act will tell you what your tenant's obligations are. With a reasonable accommodation request, for example, if you have a person with a disability who has a disability-related need, if the landlord can't accommodate can't grant an accommodation that's not requested, for example. And so we do teach our tenants that you have to make the request. You can do it verbally or you can do it in writing, but you do have to communicate that request. We prefer writing, but the Fair Housing Act doesn't require it. Person can't be denied a housing opportunity, again, that they didn't apply for. But I do want to also make the statement that the Fair Housing Act does not just apply to tenants. So you need to be aware of that. It's any person in most situations, and at least a prospective renter or a renter with you're dealing with the first provision under the disability-related provisions. So don't I guess like box it off and think that it's just landlord and tenant. It's more expansive than that. It's just you have a duty to every person who applies for a housing opportunity to treat them fairly as is defined by the Fair Housing Act. Yes, ma'am.
I don't know if I'm jumping the gun or if it applies under fair housing, because we didn't, or I haven't heard yet about felonies. So that's our biggest question in the back row is, I don't know if that's covered under fair housing or is that the landlord tenant?
Actually, well, there are some statements under the Oklahoma Residential Landlord Tenant Act dealing with felony provisions within a lease, but it would also apply to the Fair Housing Act. My example was different terms and conditions where the landlord was only enforcing criminal background bans or checks for people who were non-white. There is a statement on the HUD.gov website. You'll have to not Google it, but do a search for criminal background policies. I believe HUD issued it in 2016 that talks about how it's not illegal for a landlord to have that type of policy, but that policy has to, there are certain parameters which then those policies have to fit, and it has to be applied uniformly. You can't have blanket look-back periods, because the further that you get away from the person's conviction, it's not going to be as justifiable to have that. So that's a really long conversation, and I'm running out of time, so we can talk about it later. And I'll be right there. I'm not leaving until the end of the presentation.
Okay, one last question.
Okay, it sounds like there's plenty of, plenty of legal ramifications and protections for the tenant. Is there a website that landlords might look to for our different legal options and pursuits of, such tenants that don't live up to the end of the bargain or, skip town or what have you?
Well, see, and that would probably be a landlord-tenant issue, and that's not really, that's outside the scope of my presentation, and I can't give you legal advice so far as that is concerned, but I can tell you that if you go to the HUD.gov website, it will tell you what it will give examples of what is discrimination and what not to do. So, okay, thank you everybody. So I'm here afterwards if you have any questions. Have a good day.
Okay, so we're gonna take a quick break and let's get back together about 10:10, so 10-minute break, and then we'll have Eric. Another thing to point out, we do have this All right, welcome back for our next section of Housing 101. We're going to have Eric from Legal Aid talk about the Landlord-Tenant Act. I think we got our microphone issues taken care of. Thank you for being patient. Again, there's a copy of the Landlord-Tenant Act in your folder, and I highly recommend that you get it out and kind of follow along with him as he goes, and it'll make it a lot easier to understand. And we're going to go ahead and get started. Thanks.
Thank you, Kendra. Good morning, everybody. If Mike gets too loud up there or has a lot of feedback, we might have to turn it down. We'll address that when it happens. Somebody start waving their arms, and we'll know. So I'm going to be talking about the Residential Landlord-Tenant Act. And that is a lot different from fair housing, because while fair housing is generally applicable to all housing situations, including landlord-tenant situations, the Landlord-Tenant Act is actually narrowly confined to just landlord-tenant situations, and it talks about the rights between landlords and tenants, the rights that both sides have, and their obligations towards each other. It even gives us information about situations in which, we might not have even anticipated when we were agreeing to enter into a landlord-tenant relationship. All right, so first, I want to talk a little bit about eviction. So what happens in landlord-tenant situations is that at some point, if the relationship goes bad, they might end up in court. And most of the time when they end up in court, it has to do with rent. The landlord says, "Where's my money?" And the tenant has some reason for not paying. It may be that the tenant didn't have money, or it may be that the tenant withheld the rent. But it's not always a money issue. However, it's almost always a money issue. So why do we not pay our rent? A lot of times, it is a one-time financial setback. And this is where, a good dialogue between the landlord and the tenant might, resolve a lot of problems before they even start. But illness, automobile problems, debt collection, those are the reasons that people often have a one-time financial setback. But sometimes there's a long-term financial setback. When that happens, that's when the landlord and tenant need to talk about, is this the right house for you? If you're not going to be able to afford to live here over time, maybe we need to sever our relationship. Maybe you're not going to get additional income. And people who are poor tend to lack savings. There's definitely a lack of affordable housing in America. 1 out of 5 people who could benefit from affordable housing actually have access to it. That's just where our current funding level is at for affordable housing. And then we have a lot of cost-burdened families. We have so many families in Tulsa County who are spending more than 50% of their gross income just on their housing needs. And HUD tells us that if you spend more than 30% of your gross income on your housing, which would be your housing payment plus your major utilities, then you are less likely to be able to afford other life needs such as food and medical needs. So we have a lot of cost-burdened families, and that, can spiral out of control and create a situation where a person can't afford their rent. And then lastly, we also have some predatory landlords. You do not want to be on the other end of a disagreement with me if you are using your housing as a way to suck every tenant dry. So we do have a lot of landlords who are charging excessive late fees, hundreds of dollars per month, charging fees that aren't lawful, fining their tenants. You park in the grass, you owe me a fine. Well, the landlord's not the police, so no, the tenant doesn't know a fine. However, people end up in landlord-tenant court over that. But it's not always a money issue. People end up with disagreements for other reasons. Retaliation is the number one. Now, we talked about retaliation a little bit in the context of fair housing, but I see retaliation all the time when it comes to a tenant saying, "Hey, Kendra from the health department, my toilet's got bad water coming out on the floor." And the landlord says, "How dare you get the health department involved? I'm going to sue you for eviction." I see a lot of those cases. And that involves substandard conditions generally, reporting to the health department, just complaining, "Hey, I've got a hole in the wall, could you fix that? Well, you're out of here. If you don't like it, you're out of here." Sometimes the landlord just wants to get out of the business of landlording. wants to sell the unit, or they die and the family doesn't want to take on that landlord responsibility. Sometimes it's discrimination. We see that, especially people that have been there a while. Maybe it becomes an issue where the tenant asks for an accommodation and the landlord says, well, I've decided you need to leave. That can get very expensive, as Teresa was talking about earlier. I'm sorry, Teresa, I didn't get your name wrong, even though we work with her today. So discrimination could be a reason why people end up being evicted. And then sometimes the tenant just wants to leave, and that creates problems. Maybe there's domestic violence, maybe their needs changed, maybe they knew they weren't going to be able to afford it, right? So there's a lot of reasons why these relationships go bad. And it matters because eviction is a cause of poverty. So if we end up in housing court, I hope we're being thoughtful about it. Not only does the tenant risk losing all of their possessions, but it's a destabilizing event because they also lose those social connections in that neighborhood, that support network that they've built. So it could be that, you know, this tenant, she's a working mom and she has to go to work, and the person across the street has kids the same age, and they offer the rides to school for the kids, and they all kind of work together as a community. So it can be emotionally also devastating because we're talking about uprooting people, moving them to someplace new. It ruins credit. And what they say is that it takes 2 years to recover financially from an eviction. And also, lastly, we know this is a racial justice issue because African American tenants, especially women and women with children, are much more likely to be a victim of eviction than anyone else. Now, don't get me wrong, eviction has its place. If we have tenants who are destroying property, or not paying their bills, eviction has its place. However, it should be thoughtful. All right. And the reason I talk about eviction is because in Tulsa County, we have one of the highest eviction rates in the United States. Tulsa County, as you might have seen in the paper, in 2016 was found to have the 11th highest eviction rate in the nation. Our eviction rate has not gone down since then in any significant way. We do have an eviction prevention project at Legal Aid that is tentatively looks like it's bringing some numbers down year on over a year, but not in a way that's going to take us off that list of, you know, cities where eviction is in fact a crisis. So let's talk about the basics of landlord-tenant law. The truth is, I want this to be about, you know, your rights and the tenant's rights and everyone's relationship under the law. This is not really a manual for how to evict people. I did want to talk about eviction just to give some context, but really the landlord-tenant law is about, you know, this relationship and what its parameters are. So the first concept that's important to know is that there might be a written rental agreement, or there might not be one. If I come to you and say, here's a stack of cash, can I stay in your house for a month, and you move out, you hand me the keys, we've entered into an agreement, even though there's nothing on paper. What the Residential Landlord-Tenant Act does is it defines that relationship. So whether you have a written agreement or you don't, the Tenant Act, the Landlord-Tenant Act says, you know, this is the minimum that you must have, and you can't do more than this. You need to fall somewhere in the middle. But if you want to be in the business of renting places as a landlord, or if you're a tenant finding yourself in court, you're also going to need to know the Small Claims Procedure Act and the Forcible Entry Detainer Act. Those are very small. They are written in old-timey lawyer speak, but you can find those there in the law. It tells you how to serve your tenant. It tells you what's going to happen at court, basically. However, the Residential Landlord-Tenant Act that you have in your materials is really the meat and potatoes of this. It's what defines the relationship. All right, so there's a couple things that are required whether or not you have a written agreement. First, all parties have to act in good faith. That just means retaliation. That's not good faith. That's being a bad person. You need to treat each other, you know, above board. I mean, you go to court, if the judge starts hearing stories about you're doing this in retaliation, you're punching holes in my wall because you're mad, the judge is gonna start screaming at everybody. So everyone needs to act on their best behavior. Doesn't mean you can't be upset, you just can't make bad decisions because you're upset. And then next, all parties must mitigate their damages. Now that's just fancy lawyer speak for don't make things worse than they already are. So if a tenant decides to move out before their contract is up, well, the landlord might say, hey, I'm gonna lose 6 months of the rent here that you promised to pay. And I'm just gonna sit back and wait for 6 months and then sue you for those 6 months because you've already promised to pay them. Well, you're actually making your own situation worse. The law is gonna require you to try to rent your house for those 6 months. You have to try to mitigate, make it less damaging than it already is. And then lastly, the winning party to any lawsuit in housing court is going to be entitled to a reasonable attorney's fees and their court costs. And that goes for landlords or tenants. So whoever's suing whomever is suing who in court is going to be at risk of having to pay the other side's attorney's fees and court costs if they lose. And tenants can sue landlords in housing court. It's not just a one-way street. Which way am I going? All right. There we go. 2 types of housing. So we have subsidized housing, we have unsubsidized housing. The only reason I bring that up is because people in subsidized housing have rights that are in addition to the rights and remedies given under the Landlord-Tenant Act. So if you're in subsidized housing, there's going to be certain rules that apply to you that are in addition. If it's a Section 8 tenant, which most of the landlords in here, if they have anyone subsidized, it's a Section 8 tenant, there's not going to be any necessarily additional rights or remedies for you to understand, except that, you know, during the term of the lease, that 1-year lease that you start with, you need to have a good reason for getting rid of your tenant. You can't just put them out. And basically what it comes down to is there is a good cause standard to evict or not renew the lease. However, there are additional notice procedures for public housing and project-based rental assistance. However, for typical Section 8 landlords, it's not going to make much difference. And we can hold all questions they not appreciate it. All right. So, how do we create a tenancy? What needs to happen for us to be in a landlord-tenant relationship? Well, like, yeah, it can be with or without a contract, but what it comes down to is we just agree. I agree that you can move in, and you agree that you're going to pay rent. In that agreement, the landlord continues to own the unit. The landlord has the right to receive the rent for that unit. And they have the right to receive that unit back in substantially the same condition as I gave it to you. Now, people live in homes, and homes over time are susceptible to wear and tear. Normal wear and tear, the landlord can't do anything about that, the tenant can't do anything about that. That's expected to happen. If there's carpet, people are going to walk on carpet. 5 years later, that carpet's not going to look the same. You can't expect that the tenant would pay for that carpet. So the reasonable wear and tear is one thing. Now, if the tenant's doing things to destroy it negligently or intentionally, different situation altogether. So the landlord has those rights. But they give up the right to possess the unit. The landlord gives up the right to be there. And they can only enter after giving it a notice unless there's some kind of emergency. And the landlord is responsible for maintaining and repairing the unit. And even when you have in your contract the tenant will make all repairs, it doesn't matter. The landlord-tenant law says the landlord is responsible for that. And you can't write something in your contract that changes what the law says. The tenant has the right to possession of the unit. They can even exclude the owner as long as they're being reasonable, right? The landlord has a reasonable right to enter. We'll look at that in a minute. But for the most part, the tenant has the right to be there in that unit and to keep everyone else out. Tenant is required to pay rent, and the tenant cannot damage the unit, except for normal wear and tear. And if it's normal wear and tear, we all live in homes, we know what normal wear and tear looks like. I guarantee you the judge knows what it looks like. So it's kind of, just what's reasonable here, what's normal for what people do when they live. All right, so the rental agreement, whether or not it's oral or written, the terms are defined for you by the law. If your agreement doesn't say what rent is, then the rent is the fair rental value. So if my cousin Jed comes and says, I'm gonna live in your shed in your backyard, and I say, okay, you just gotta pay me rent. And then Jed moves in, and I come around at rent time and say, I want $1,000. And Jed says, no, this is a shed. I'm gonna give you $50. The court would sit down and determine whether or not I was right or Jed was right, or if it was somewhere in between. The truth is, I bet Kendra's gonna be unhappy if anyone's living in a shed. So what's fair? It comes down to what's fair. For a month-to-month tenancy, which is most of tenancies, rent is due at the beginning of the month. If you don't have it in a contract, if you haven't discussed these terms, if you haven't written them down, it's going to be month-to-month, and it's going to be due at the beginning of the month. If it's less than a month-to-month because the person lives in a room in your home, then it's, on that 7-day cycle. So you can have a week-to-week tenancy and a month-to-month tenancy, but most of them are going to be month-to-month with rent due at the beginning of the month. Regardless of whether or not you have it in writing, or even if you have or haven't discussed the terms, your rental agreement has some things that can never be there. And if they're there, they don't count. So your rental agreement can't say you don't get the rights under the Landlord-Tenant Act for the landlord or the tenant. It can't take away either side's rights. You can give extra rights, but you can't take away. Your rental agreement can't say that any one side automatically wins, and I see this in leases all the time. If we go to court, I automatically win, and you owe my attorney's fees. Cannot happen. That is an illegal provision. The court will just ignore it. You cannot waive any damages for the conditions of the property, and I see that a lot in when the landlord says, oh, you're responsible for the complete maintenance of this house, and if anything breaks down or something, it's your fault. No, the landlord is responsible for maintaining the home, and damages caused by defective conditions, such as a stair railing that's not attached on the outside of the building, or a balcony that's hanging off. If someone gets hurt by that, that's a landlord liability issue. You can't put that on the tenant. A lot of people's favorites right now are the tenant shall get insurance on the property in case someone gets hurt by the landlord's negligence. You can't do that either. You're shifting the landlord's burden to the tenant. And you cannot create a lien on tenant property. So I see this a lot in leases that says, the landlord has the right to enter your unit and take all of your property if you fail to pay rent. But that's just not true. There are very limited circumstances when you can have a lien on tenant property. And it has to do with tenants leaving property behind. There's certain property that's exempt that we'll talk about. And it's only for certain purposes. For the most part, you cannot own the tenant's property just because you wrote it in your contract. And then lastly, no contract in Oklahoma can contain penalties. And so we see a lot of things like fines. You park on the grass, you owe me a fine. Well, that's a penalty, and only the police or the law enforcement or the city or the state can issue penalties and fines. Landlords are not those things. They cannot issue penalties and fines. We don't get that in court very much lately, but there are periods of time when we'll have landlords trying to enforce these fines, and they'll sue the tenant saying that the fine was rent. And then we'll have to defend it saying, this is a penalty, it's not rent. But more than that, what about late fees? Late fees are sometimes a penalty, aren't they? You didn't pay your rent on time, therefore you owe me $100. Well, if it's a penalty, then the tenant doesn't owe it. If it's reasonably related to the cost of the landlord, which is something the landlord has to prove out in court, then certainly fees are allowed. But penalties are not. And lastly, with regards to what rental agreements may or may not have, if there is something that is prohibited here, 1 through 6, then it's completely unenforceable. and the court will throw it out. All right, so what a written agreement can do, you can have reasonable limits on the use of the unit, right? You cannot use this unit to have a bakery, you know, where you're selling cakes out of your home. You can't run a business. You can have reasonable limits on the use of the unit. You don't want anyone to abuse that unit. You might say, don't run a daycare out of my unit, you know. You can say that it's reasonable to have no more than 2 people in a room, in a bedroom. That's considered reasonable by the state of Oklahoma. All leases must contain the name and address of a manager or landlord or owner so that the tenant can send written notices to that person. And there can be reasonable rules. So the landlord can have rules about, if you live here, you must follow certain rules. There are limits on what the rules can be, and there's an entire section, section 126, that tells you in your Landlord-Tenant Act what those rules can be. Any other rules outside of that aren't going to count. And lastly, all leases must disclose any flooding that's occurred in the last 5 years. If you fail to disclose flooding of a unit and it floods, then the tenant can sue the landlord for the damage to their property. Also, methamphetamine. Anyone's been cooking meth in your unit, you have to disclose that before anyone signs a lease. There are certain provisions, and there in section 118C, and you can see how to abate methamphetamine so that you don't have to disclose it if you have certain tests showing that it has been cleaned up. When it comes to flooding, that does need to be prominently put into your lease. We don't have any real cases about flooding, but I have used this in court before. And basically, the law says that flooding is the inundation of normally dry areas of land through inland rivers and streams. So basically, water backed up from the river. I mean, it's flooding. I have used that before to say that we have created a system of inland rivers and streams through our plumbing network, and then backing up plumbing onto normally dry floors is a flood. I've used that in court, and I think it worked because I won. I'm not sure if that's legit or not. No, I will argue that because it's a waterway that we created and it backs up. All right. So the rules during tenancy, right? After you move in, before you move out, what rules can we have in place? First, and this is important, and this one is hard, I think, for landlords to accept sometimes. I'm also going to talk about tenant responsibilities. Don't get me wrong, I'm not hard on landlords, but I mean, we mostly have landlords here, so I want landlords to be aware of what the rules are for them. At the beginning of the term, right? So when you sign the lease for 1 year, the beginning of the term is the move-in. Right? If you're on a month-to-month, the beginning of the term is the first day of every month. At the beginning of the term, the landlord must give full possession of the unit, in accordance to the lease and in accordance with the law. And so section 118 that we're looking at next tells us what the landlord must do throughout the tenancy. But what it also says is at the beginning of the tenancy, all of these things must be present if you are to be giving full possession. And the law requires you to give full possession. So 118 says at all times, the landlord will keep common areas clean, safe, and sanitary. That's for apartments, right? Not for single-family dwellings, but for apartments, all areas will be clean, safe, and sanitary in the common areas. And for apartments and houses, at all times, the landlord will make all repairs and do whatever is necessary to keep the unit fit and habitable. Whatever is necessary. It includes maintaining safe working order of electrical, plumbing, sanitary, heating, venting, air conditioning, and other facilities and appliances supplied by the landlord. So when the tenant moves in, the appliances should work. The heat and air should work. Because at the beginning of the term, the landlord's going to do all of these things. And throughout the tenancy, they're going to do these things. Provide for trash and waste removal, and supply running water, reasonable amounts of hot water, and reasonable heat at all times. Now, if the tenant is in a unit where they pay for their own utilities, the tenant is responsible for keeping those utilities turned on, right? If I'm responsible for water, it's my job to pay my water bill. And if the water gets shut off because I don't pay my bill, that's not the landlord's failure to supply water, that's the tenant's failure. However, if a pipe is burst and water can't come through, even if the tenant's responsible for paying for the water bill, the landlord's responsible for the pipes. So that's where you might end up crossways with your tenant. Especially since a lot of tenants come to me and say, hey, my water bill was $300 last month. And we're like, well, you got a water leak. And they're like, of course I have a water leak. The landlord knows I have a water leak. The tenant should be responsible for that $300 is what they're going to tell me, because the landlord was responsible for the pipes. But we'll get to that in a second. All right. So 117 said you will deliver full possession. 118 tells you what possession is. 120 says that if you fail to deliver possession, right, rent abates. Means I don't owe you money until you give me possession. And the tenant can choose to terminate the agreement and ask for all prepaid rent deposits and move. That's at the beginning of the term, and again on month to month, that's the beginning of every month. The beginning of the term, if possession is not given, the tenant has the right to not pay rent, to have their money back and leave, or can sue the landlord for possession and make you do those things that weren't done. Now, if they can show the landlord's failure to deliver the possession was willful and not in good faith, they can get 2 times the monthly rent as damages. So, currently, it's hard for tenants to sue landlords for these kinds of things, absent going through legal aid, and we have lots of cases. So, mostly we'll just do phone calls, right, and say, hey, buddy, can we get this water on? But know that that's an option for a tenant, and that's a liability that has to be taken into consideration. But what about for the rest of the tenancy, not at the beginning of the term? Well, if it's not at the beginning of the term anymore, then there are different remedies for tenants depending on what's going on. So, if we're talking about essential services, heat, hot water, those things that we need for sustaining life, those things that Kendra and other members of the health department will write you a ticket for, or give you a phone call, or whatever she does. She'll tell us in a minute. If you don't give those things, the tenant can do any one of these 4 things. They could immediately terminate their agreement and move. Our lease is done, I owe you nothing, I'm out of here. They could purchase reasonable amounts of the essential service that you failed to deliver and then deduct it from the rent. So if you're not providing heat and I go out and buy a bunch of space heaters and my electric bill goes up $500, I'm going to charge you all those space heaters and that $500 because I had to do that for the failure to deliver the heat. The tenant can sue for damages based on the decreased rental value. So the question then is, hey judge, this unit's not worth $800, there's no heat. I say this unit's only worth $100, and the judge can say, I agree, and then lower the rent by $700, or whatever amount the judge comes up with. The question is, what is a unit worth that has no water, or no heat? If the health department would condemn it, I guarantee you it's worth 0. And that's what I argue in court too. If I have a letter from the health department that says 10 days to fix the sewer backing up on the floor and no water, I'm going to tell the judge my tenant owes $0 for this done. And that's just what happens. And she will do it. All right. Lastly, they can rent substitute housing and stop paying rent during the period of time when the unit's out of compliance. And that's what people do most often, right? They move in with mom, and they say, hey, I had to live with mom for a week until you got that back on. I don't want to owe you rent for that week. And that's where we end up in landlord-tenant court. You didn't pay me all your rent from the landlord. The tenant's saying, I don't owe you all that rent. All right. So non-essential services are those other things, right? If the landlord doesn't comply with the lease, or with 118, which was the landlord duties, then the tenant may give written notice of the non-compliance, give the landlord 14 days to fix it, If the landlord doesn't fix it, they can terminate their lease and leave. That's what their right is, for the most part. And their lease the notice just needs to say, you need to fix these items. If they aren't fixed in 14 days, I will move out, and I will know you anything else. But sometimes those non-essential services are repairable. And so another option tenants have is to say, hey, landlord, you have 14 days to fix this problem, and if you don't fix it, I'm going to fix it myself. Now, if the tenant does that, they can deduct up to $100 of that cost from their rent. Now, if they won't go out and buy an air conditioner for $500, they're only going to get to deduct $100 unless they can say it's an essential service. So maybe not that one. Let's think of a different thing. The wiring to some light is bad, and the light won't stay on. In the one room, I'm going to fix this light, and I'm going to go out and pay $50 for a new light fixture. I can deduct that $50 if the landlord doesn't fix it. But if I'm at a $500 light fixture, I can still only deduct $100. All right. If there's an emergency, you might get less time than 14 days to fix it. If they do deduct costs, they have to give you an itemized list of those costs, and everybody can report and show the judge, hey, this is what the costs were. And again, the notice must just say, you have 14 days to fix it, or I'm going to fix it myself. All right, so did I skip one? I did not. All right. Landlord, the tenant's supposed to tell you if things are going wrong and you don't know about it. I mean, how fair is that if you don't know that something's wrong? And all their rights, all the tenant's rights, only come into play once they give a written notice about it. For a long time, that was a barrier that tenants couldn't provide that written notice. Today, we all use text messaging. So that barrier has kind of lifted, right? I'll go to text message you and talk to you on the phone. Anyway, dear so-and-so, please fix. Note that if we're going to court and we need to bring written things, the judge is not going to look at your phone. The judge is going to look at the tenant's phone. It's not going to look at the landlord's phone. Everyone needs to print that stuff off. Our judge hears 14,000 evictions in a year. And cell phones are nasty little germ-holding things, and I am not going to touch the place where you've been coughing, or kids have been playing with. It's not going to happen. So print your text messages if that's the notice you want the court to look at. All right, so we talked about rules. Landlords can have rules. I've seen some really crazy rules. There's a place that's a project-based rental assistance place that's kind of shaped like an H, and it has interior hallways that all the doors go to, such like an old hotel, and they had a rule in their lease that said you cannot walk in the hall without shoes on. And I thought, that's the craziest rule I've ever heard. How dare you tell me not to leave my house without shoes on? However, we'll look at it. If the purpose of the rule was to promote the convenience, peace, safety, or welfare of the tenants, then that's okay, as long as you meet all these requirements. Or if the purpose was to preserve the landlord's property from abusive use, such as don't hold a bake sale on my property, right? Or to fairly distribute the amenities or services to all tenants, well, then that rule may be okay. Also, the rule has to be reasonably related to the purpose for which it's adopted, and it has to apply to everyone in a fair manner. It needs to be clear and understandable, and it needs to be there for the tenant at the beginning so they know that this rule is there. Or if that rule comes into place later, the tenant has to accept it and sign off on it. So when I go back to my no walking in the hall without shoes, the reason the landlord gave was, we have a lot of drug users and pushers that come through these hallways, and they leave needles laying around, and I don't want someone getting Hep C from stepping on them. Suddenly, I thought, your rule's pretty good, right? You're doing it for the peace, safety, and welfare of the tenants. Now, what I told that landlord was, perhaps you can keep the drug dealers out of your hallways. Then you won't have this problem. But, I mean, I'm just saying that giving crazy rules could be okay. A lot of rules, though, I hear just aren't, really, they're not always good rules. Sometimes it's just a matter of, this is what I want, this is what I want. Case-by-case basis, though. All right, so a landlord's right to enter the unit. We talked a little bit about the fact that when the tenant takes over the tenancy, they have exclusive possession and the right to tell you that you can't come in. But the landlord does have a right to come in. It's my property. I have the right to make sure that it's in good working condition, that I need to make the repairs that I'm required as a landlord to make under Section 118. So the landlord can enter, they just need to give it 1 day's notice. And it needs to be reasonable, right? I'm not gonna give a 1 day notice to enter your unit at midnight, unless of course you work nights and you ask me to only come over at midnight, maybe that's different. But generally, if you're saying, hey, I need to enter, here's 1 day's notice, it should be okay. If you do it day after day after day, suddenly it becomes abusive and harassing, right? You can't do anything that gets abusive and harassing. The tenant can withhold permission to come in if it's reasonable for the tenant to do so. So let's say the landlord says, I'm gonna be in your unit for 24 hours. And the tenant says, whoa, 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 we have a plague event in here. Kid is sick in this room. You do not want to come in right now. You know, maybe it's reasonable not to come in. Or the tenant's in the shower. I can't let you in right now, naked. That's the one I hear a lot. But the tenant should allow the landlord to enter. You know, they should, unless it's reasonable not to. They should say, hey, I'll be done in the shower in 10 minutes, you know, come back in. If the tenant refuses to allow lawful access, the landlord may get a court order. And if the landlord is using their right of access in a way to intimidate and harass the tenant can get a court order that says you can't come over anymore. It goes both ways. Now, in the case of an emergency, the landlord can always enter without advance permission. Obviously, if the pipes have blown up and the water's flowing through the unit, you need to get in there and get that off, right? That's an emergency, or if it's on fire, or if someone's died in the unit, or if the police say, I need access to this unit. There are times when you don't have to give advance notice, but generally 1 day, as long as you're being reasonable, the tenant's gonna have to let you do it. However, unlawful entry, or abusive entry, or an unreasonable entry, that could result in damages from the tenant suing you, right? Because they get a court order to stop you, they can terminate the rental agreement, and they can sue for damages. So it's important to recognize that while you have a right to enter, you don't have a right to do it just to harass and intimidate. That could land you in trouble. Tenants' responsibilities, I told you we were going to get there, right? Tenants shall, at all times, keep their part of the premises as clean and sanitary as conditions permit. Landlords all the time say, hey, I need to inspect your unit to make sure that you have cleaned up the mess. And that's perfectly acceptable. Tenants are supposed to throw away their trash and their ashes and things in a sanitary manner. That is a tenant responsibility. Landlord's not responsible for cleaning up their mess. I think number 3, keep all homing fixtures and units as clean and sanitary as conditions permit, was written a really long time ago, and I'm not sure exactly how that applies today. I just wipe down your sink. And then they need to use in a safe and non-destructive manner all electrical, plumbing, sanitary, heating, ventilating, air conditioning, and other facilities. They need to not break things. Tenants are not allowed to negligently or willfully destroy things. Reasonable wear and tear is okay, but they can't just go around breaking things. That's a no-no. Shall not deliberately or negligently destroy or damage things or allow their guests or their animals to do it. They should not engage in any conduct that will disturb the quiet and peaceful enjoyment of all the other tenants. That's probably the number 2 complaint I get in landlord-tenant court. That's not money related. This person's loud, they're disturbing their neighbors. The neighbors have had it, I've had it, I want them out. Tenant must comply with all landlord's rules, so long as they're proper rules, right? Wear your shoes and don't step on needles. And then tenants are allowed to engage in criminal activity if it threatens the health and safety or right and peaceful enjoyment of others. Excuse me. And they are not allowed to do drug activity regardless. So I I had a tenant once who was being sued for eviction because she shoplifted at the Promenade Mall. Well, the Promenade Mall was 5 miles away, did not in any way affect the health or safety of any of the tenants at the unit. I mean, it was criminal activity, but it didn't bother the other residents. And so that was not a proper eviction, and we got that one tossed out. However, if they were robbing the person in the unit next door, that would be a problem. I recommend calling the police in that situation, and then you can evict them while they're in jail. Okay. I mean, that's what it's for. I mean, if they're committing crimes, people need to not destroy or harm your unit in that way. Property owners certainly have a right to try to maintain some safety for their other tenants. So, if there's non-compliance by the tenant, and that non-compliance can be remedied by fixing or cleaning, right? The landlord needs to give written notice and require the tenant to make the repair, replace, or clean within 10 days. And then after 10 days, the landlord has the right to enter and do it for the tenant and send them a bill. Here you go, here's a bill. You didn't do it, I told you to clean this up. Fine, I'll come in and clean it, here's your bill. And if the landlord chooses this route, then they can't file an eviction. So that's one route you can choose. Another route would be tenant breaches, maybe where there is no ability to clean or repair, or the landlord just doesn't want to follow that route. Then the landlord can give notice of non-compliance, say you need to fix this within 10 days, and if you don't fix it in 10 days, I'm going to terminate your lease and put you out. So 10 days to fix it, 15 days later, if it's not fixed, the landlord can terminate and then sue for eviction. So in both of these situations, and actually in all the situations that we're going to look at, the important part to remember is that the notice, either from the tenant to the landlord or from the landlord to the tenant, is giving that other side an opportunity to comply, to preserve the arrangements. If you comply, we're all going to be good, and we're going to move on. It's when the parties don't comply that you have the right to go to court. All right. So, if the non-compliance with the tenant threatens to cause imminent or irremediable harm to the property or other persons, and it is not fixed as promptly as conditions require, then the landlord can terminate the rental agreement and file a forcible injury for detainer, and there is no waiting period. The waiting period is you need to do it as quickly as the situation requires. Now, the warning here, that's what the law says, but if you go to law school and you learn all the due process, at some point you might notice that not giving a tenant an opportunity to cure could create a due process problem. Totally different issue. Speak to a lawyer if you don't want to give someone an opportunity to cure. Okay. There can also be an immediate termination of lease for criminal activity threatening health and safety that's committed by the tenant or the person that lives with them or someone that's their guest, especially if it's criminal activity that's a danger to the premises or drug-related activity. An immediate termination of the lease. Now, in that case, you're not giving them any opportunity to fix it. Again, that's where a due process might become an issue for you, because if you don't have an opportunity to comply, suddenly you're taking property from me without me having a right to defend that. It's not been tested in Oklahoma, just throwing it out there as an option that you might want to talk to an attorney about before you immediately terminate somebody. In the practice in Tulsa County is generally they'll do like a 24 or 48-hour notice to at least say, look, this is what's going on. But regardless, if it's an imminent threat to health and safety, you don't have to allow a person to fix that problem, in my opinion. The judge isn't going to make you anyway. People need to act right. Okay. All right, so terminating a tenancy, moving or being removed. So unpaid rent is the #1 reason we end up in landlord-tenant court. Now, the fact is a lot of times people are behind month to month to month to month, and the landlord never does anything about it until the tenant one day calls Kendra at the health department, and then suddenly the landlord wants all their money. That's a dangerous situation. That's a retaliation. However, this is the mechanism. If someone's not paying you rent, right? If it's unpaid when due, you can sue for rent. doesn't put the tenant out, but it gives you a judgment. Alternatively, you can give your tenant a 5-day notice that says you have 5 days to pay the rent that is due, or you can move. And if you don't pay your rent or move, I'm going to sue you for eviction. You can get a money judgment, possibly, and you can get an order for possession to put them out. 5 days, it's all that's required to make someone compliant with rent. The issue is, what is rent? Right? Rent is all money that's owed to the landlord except deposits and damages. So deposits, I see landlords sue for deposits all the time. You didn't pay $300 your deposit, I'm suing you for 5 days, 5 days notice. Well, 5-day notice will not count on a deposit because the deposit is not rent, and the 5-day notice is only for rent. But late fees, what you might not know, are damages. So the law defines late fees that are proper and not a penalty. If it's a proper late fee, it is a liquidated damage. And damages are not rent. So we shouldn't be suing tenants on a 5-day notice for damages. Doesn't mean you can't try to collect them. It just means that it's not proper for a 5-day notice. The 5-day notice needs to be for rent, right? The tenant's opportunity to comply is to pay the rent, not the late fees, not the deposits. If you want them on late fees or deposits, it's a 15-day notice or whatever, whichever notice, we'll get to it. All right. If the tenant wrongfully abandons, right, and says nothing, just packs up and leaves, and you go to collect rent and they're gone, that's when we talk about mitigation. Landlord has to try to re-rent it. If the landlord tries to re-rent it, does everything normal to try to re-rent it, and they just can't re-rent it for the rest of the lease term, or for some period of time in there, they can sue the tenant for that period of time when they didn't get rent, as long as they were making an effort. Month to month, you can terminate on 30 days, right? We're on a month-to-month lease. All I have to do is give you a 1-month notice. If it's a 7-day lease, a week-to-week, I give you a week's notice. Month-to-month can be terminated for any reason, as long as it's not an improper reason. And the fact is, the best reason is, this is your 30-day notice without any reason. Because once you start giving a reason, you set yourself up for failure, right? You cannot give someone a 30-day notice because you are intending to discriminate, right? Oh, you want an accommodation, 30-day notice. It happens. I just won a huge lawsuit on that. Twice in the last year. All right, retaliation. So both of those lawsuits, both women in those cases, the landlord said, oh, you want an accommodation, that's never going to happen. And so the tenant said, fine, I'll just call HUD and you can deal with them. And then that's when the landlord said, you called HUD? You're out of here. That was retaliation. That's why they got huge jury awards against them. Filing an eviction against somebody because they asked for an accommodation, even if they were not entitled to the accommodation. If you do it because they asked for it, you're breaking the law. All right. 7 days for a week to week. A lease that's for a definite term, like this is a 6-month lease, ends without notice. Just ends, and the parties are supposed to settle up and leave. If the tenant continues to live there, the landlord continues to take money, it's a month to month. All right. So these are kind of what we talked about before. If the landlord fails for possession, there's the tenant can leave. For fixes, it's a 14-day notice. It just kind of sums up what we talked about earlier. For the tenant breaches, if the tenant's not in compliance, they need to fix within 10 days, the landlord can terminate after 15 days. Or if the tenant is doing something that is an imminent threat to health and safety, there may be a right to immediately terminate. Criminal activity could happen as an immediate termination. What's important to remember for if you're going to evict a tenant for criminal activity is that the burden of proof is on the landlord to prove there was criminal activity. And a lot of times the landlord didn't see anything. They just heard about it. But that's hearsay, and the court might not accept your evidence. Plus, you're not in a criminal court. Our previous judge would say, hey, I'm not here to decide criminal matters, so if you're saying there's criminal activity, you need to show me a conviction. I mean, that can take a year, right? So The best practice is if you know there's criminal activity, call the police, let them handle it, give the notices while the person's incarcerated. I know that doesn't sound fair, but I mean, that's kind of what the point of this provision is. If the person's committing crimes, you can get them off your property. But arrest alone does not prove criminal activity, so that's a pitfall to watch out for. If you want to get someone out for criminal activity, I strongly suggest hiring an attorney. All right, so the eviction process starts with this notice. Okay, you cannot file an eviction against a tenant without first giving the notice. And a tenant cannot terminate the lease and leave or sue the landlord without first giving their notice. So the notice needs to be done, and then after the period to cure has passed, if the parties have not complied with what they were supposed to do, that's when the right to file an eviction or otherwise seek a court order comes into place. So those notices that we just looked at have to be served on the tenant, and it's different than serving a lawsuit. The landlord can just give it to the tenant personally, or the tenant can just give it to the landlord personally. No need to hire a process server. If the tenant cannot be located, service will be made by any person in the unit that's at least 12 years old that lives there. So, can you tell your mommy she needs to pay rent at the end of the notice, right? But those two steps must be taken first. You have to attempt serving the tenant, and then you have to attempt serving someone in the tenant in the unit. And if you cannot do that, then you can post that notice there on the door in a conspicuous place. 5 days. But if you do that posting, right, you have to also send a certified mail. And the court will make you prove that you posted the notice and you sent it by certified mail. So keep your receipts. All right, so let's say that the person didn't comply, you have the right to file a forcible entry detainer action. The court will have jurisdiction to hear forcible entry detention or detention only. That just means possession. The court has the right to decide whether it's the landlord or the tenant that's entitled to possession of this unit. Claims for the collection of rent and damages to the premises. So if you say, hey, judge, they owe me $500 in rent, plus I also had to repair this door that was $300 and they haven't paid for that yet, and I've given them notice of that need, and you can add that to your case also. And then the court can hear anything arising under the Residential Landlord-Tenant Act. You can't include anything else though. So you can't include, I went to collect my rent and she punched me in the face, and so I want damages for my broken nose. No, that doesn't count. You'll get an affidavit, it's a court clerk has it, there's a summons, you'll have to pay a filing fee, and then your hearing date's 5 to 10 days from then. Right? It has to fall within 5 to 10 days after you show up to court and pay all this money. It's currently $58. And you get your paperwork filled out for you. Now, at this point, you have to serve the tenant. It's a lawsuit, and so you can't serve the tenant with a summons. The sheriff can, a process server can, the court clerk can do a certified mailing, and the summons must be served at least 3 days before the trial. If it's not, your trial gets continued. The return of service must be filed. The person who served it just needs to file something saying, I've done the service, no later than the time of trial, or the court's going to give you a new hearing date, you're going to have to re-serve them and come back. So, it can be served by leaving a copy with someone who's at least 15 years old in the unit, and you must try serving it personally. If it can't be made personally, then it can be posted to the door. If it's posted, it needs to be certified mail, the court will check these things. And if it's posted, it's possible that you will not get a money judgment for rent owed. You will only get possession of the unit. Now that depends on whether or not the tenant shows up. If the tenant shows up to court, service is waived. Even if you didn't serve them, if the tenant shows up to court, it's just like they were served and you can have a money judgment. But if you didn't serve them and all you did was post it and the tenant doesn't show up, then you cannot get a money judgment against them. You can only get a possession order. All right. And that's what this one is about. All right. So the tenant is not required to file anything. They have the right to file an answer. And if they say, I have a property interest here that's beyond just being a tenant, say this is a contract for deed, you're not in a landlord-tenant situation anymore, then your case will be sent to a different judge. And it'll be an injunction action, and it's kind of like foreclosure. There's a lot more steps. So possible defenses in landlord-tenant court, rent was paid. I paid my rent. These events didn't happen. I didn't punch holes in the wall. It's between the landlord has the burden of proving that it happened. A lack of notice, I didn't get the proper 5-day notice. That's my number one defense at court. All the time, I walk up to the lawyers for the landlords, and the first thing I say is, give me the 5-day notice. And they go, well, I don't have it. And I'm like, well, then we're done here. Lack of specific notice. So if you're in subsidized housing and you want to do a for-cause eviction, then those notices need to say exactly what you did wrong, and that if you do it again, you'll be put out. A lack of evidence. The landlord has the burden of proving if the landlord's the one who brought the eviction. If the tenant's the one who brought the case, the tenant has the burden of proving what happened. Sometimes I defend by saying this eviction is based on fees and not on rent, right? They did a 5-day notice for deposits, and that's not proper. They should have done a 10, 15-day notice for the deposits. Real party in interest just means that the person who's suing doesn't actually own the house. Or they have an LLC that owns the house, and that LLC is no longer in good standing with the Secretary of State. An LLC that's not in good standing does not have the right to file a lawsuit in Oklahoma. So I defend a lot of cases like that, where landlords forget to pay their yearly fee, and their case is dismissed. It just cost them $58 plus the filing of the service. And then lastly, if it's an uninhabitable unit, I might say, this unit was uninhabitable, rent is actually zero. So if the court grants possession, the person who's wrongfully in possession must leave the unit, be a landlord or tenant, whoever's there that's not supposed to be. Sheriff will assist if necessary on a 48-hour notice. They will come and drag that person bodily from the unit. That person could go to jail doing that. Only the sheriff can remove a tenant. A landlord cannot just lock the doors without the court order and without the 48-hour notice. So those steps need to be followed in order to deny a tenant their unit. If you turn off the utilities without a court order and the 48-hour notice, it's the same as locking them out. And the tenant can sue you for twice the monthly rent or for twice whatever their damages are. So allow the sheriff and the court process to take place is basically what I'm saying. Because if you try to rush the system or try to do self-help, you could end up in a lot of trouble. So other issues, deposits must be deposited into an account. Landlords do not own deposits, tenants own deposits, landlords hold deposits. If you misappropriate a security deposit, you count it as income and just pocket it from day one, you're committing a crime. Not only can the tenant sue, well, the district attorney could. So deposits are to be held in an account for deposits. You don't owe any kind of income from that. No interest is owed to the tenant. However, the deposit is there to secure your interest in the units should something go wrong. Upon termination of the tenancy, the tenant needs to make a written request for the deposit back. The landlord has 45 days to comply with that written request by either returning the deposit in full or by returning some or none of it with an explanation and detailed accounting of why. And there may be reasons why the landlord can't keep all that deposit. It could be that they had to sue the tenant for eviction and that they got a money judgment and they're using that deposit to satisfy that money judgment. It could be that the tenant left behind damages that need to be repaired. As long as you give a detailed itemized statement as to why you're not getting back your money, then you're okay. Tenant has 6 months to ask for their deposit back. And as long as the tenant asks within 6 months, the landlord complies within 45 days, most of those problems get resolved. However, if either party is unsatisfied at that point, they could sue the other. So right now, there's a real trend in multifamily properties in Tulsa to not return any deposits. That's like they literally on their books call it income. And so I'm having to sue them for return of deposits. And it's happening a lot here lately. Not usually landlords that are small private landlords. It's usually big multifamily companies, out-of-state owners, things like that. And the truth is, we would always call the landlord first with a letter saying, hey, you owe this money, you need to give us an itemized statement. You know, we always try to resolve things without going to court. All right. So small claims court, limited to $10,000. If you have damages beyond that, you're going to need to hire an attorney to go into a civil claim. All right. Some counties, not until, will require 2 separate cases for damages to the unit versus just the eviction action. Tulsa County doesn't. It's kind of up in the air. A lot of counties let you have one hearing and just schedule you to have the other hearing right after that. It's best to bring receipts, pictures. You know, you need things to prove your case. Property left in the unit. So, the tenant leaves behind property. Tenant has 30 days to try to get that property back. If a tenant owes the landlord money, the landlord can charge the storage fees of the property plus any money that's outstanding for the tenant to get their stuff back. That being said, there are certain property that cannot be held from the tenant, and we'll get to that in a second. And the tenant doesn't try to get their stuff for the 30-day period, they've disposed of, they've abandoned it, the landlord can do with it as they will. The only real restriction on the landlord is not to negligently or intentionally harm or destroy the property. So the landlord is perfectly within the right to throw away perishable goods and things that are going to go bad, make the unit stink, trash, but it's important to remember that one man's trash is another man's treasure. And so you might walk in and see this dirty old couch and think that has no ascertainable value, I'm just going to throw it out. But to that tenant, it may have a lot of value. So holding on to that for the 30 days, you can charge the storage, you may never see that money. Just kind of saves you from being sued later on. All right. So if the landlord just goes in and throws out all the property willy-nilly without any consideration for the tenant could sue. That's something to be aware of. These items the landlord cannot hold from the tenant. Tools, musical instruments, books used in the trade or profession, family portrait pictures, clothing, medical devices. That's my biggest one. The reason I'm calling the landlord says, hey, she needs her meds, she needs her glass eye, she needs her fake leg, give it back. I don't know why contraceptives are on here. I'm guessing that at one time those were more costly than they are now. Glasses, false teeth, things that are medical in nature or sanitary in nature or of real personal value, the landlord can't hold those anyway. And those things aren't really worth anything to the landlord. They're only worth something to the tenant, right? Couches, TVs, furniture, all that stuff is fair game. Except for maybe, a bed used for medical treatment. But other than that, baby items, you can't have baby items. But otherwise, the landlord can have everything else. All right, the last thing to know is the civil rights stuff that Teresa talked about. All of those civil rights stuff apply to landlord and tenants, and will cost you a whole lot more than a violation of the Landlord-Tenant Act will. Violation of the Landlord-Tenant Act really doesn't have a lot in terms of damages that to the landlord. If you mess it up, at worst, it's going to be like a month or two of rent, generally, unless we combine some other cause of action like the Consumer Protection Act or civil rights stuff. All right, and that's it. You made it. I kind of went a little over.
Oh, no, you're fine.
Okay.
So we have, get in here. All right, so we have time for questions. We'll take questions for about 5 minutes, and then we'll have a break. And so, questions? Anyone? Yeah?
Yes, ma'am.
Okay, what if you kind of like cross lines on all when it comes to housing, tenant and stuff? Because I'm on housing, so and it's the project-based voucher,
Mm-hmm.
and I'm having issues with my requirement because I'm not understanding how it passed inspection from the beginning.
So, okay, so you're in a project-based voucher, and you don't feel like it's up to the quality standards that it's supposed to be. A tenant in subsidized housing, every year will have to go through a housing quality inspection done by the housing authority. And at any time that your unit's no longer meeting the minimum federal requirements for housing quality, you can call the housing authority and ask for a new inspection.
Okay, well, the thing about that is, I don't see it being worth it if I have to go from one property to another, because I have to wait out my year before I can request my Section 8 voucher and choose something else. I don't see the benefit of it from moving from one apartment complex to the other when it's all the same.
Okay, well, I'll tell you, your situation sounds pretty complicated, and it's a lot more complicated than the standard Landlord-Tenant Act case, because you have a subsidized unit that is project-based voucher, and I can tell you that at Legal Aid, I'm happy to talk to you at any time about what's going on in your unit, because it is really specialized, and the landlords in this room aren't going to ever come across that situation. So let's talk afterwards and make sure you have my card so that we can discuss your specific situation. Anyone else? Yes, sir.
Yeah, so, and I might be in the minority here, but it sounds like it's kind of lopsided in favor of the tenant on a lot of these things. Like, okay, you mentioned that the landlord, I'm responsible for keeping up the maintenance of the property, even if we both sign an agreement saying that they will. So if I have a situation where they're breaking windows and doing things for whatever kind of reason, I'm responsible to take care of that, and they don't have to pay me unless I do.
So his question was about property maintenance and tenant intentional damages. Is that what I'm understanding?
Yes.
So in general, it is not lopsided landlord or tenant. It's actually a little bit landlord friendly, because the landlords have a lot shorter windows for their notices. The tenant has to comply in 5 days. The tenant has to comply in 14 days if they're out, or 10 days if they're out in 14. Whereas if the tenant has a problem, they have to give the landlord, 14 days, or they can leave in 30. I mean, it's like the tenant has a harder time trying to terminate their rental agreement than the landlord does. That I know from experience, because in landlord-tenant court, it's 99.9% of cases filed by landlords. That said, a landlord does have the responsibility to maintain the premises. The tenant has the responsibility to not intentionally damage it. So if a tenant is breaking windows, and if the tenant's doing it, I'm mad, punch, the tenant is responsible for that. The landlord can ask that they be removed from the unit through the eviction process for intentional damage. They would just give the tenant, a notice that they had bad behavior, that they need to fix the window. If they don't fix it or pay for it in 10 days, they only get 10 days. If you only get paid once every 2 weeks, once a month, 10 days, you might not be able to count that money. The landlord's going to have a much easier time getting that person out, because the tenant's not going to be able to comply within the compliance period. You can then sue them for the damages to the unit. So the landlord does have remedies. You're going to have to prove the tenant damaged the unit. What I know is in Tulsa County, only 65% of all cases end in default because the tenants don't even show up to court. So it'll take time, but the landlord absolutely has the right to put the tenant out if they're breaking things, and to charge them for those and sue them for damages. Yes, ma'am.
If you're living in a situation where you fulfilled your 1-year lease, now you're on month to month to month, and your landlord says, I'm gonna sell this property to a real estate company or another landlord. You inquire about your deposit, and they said, oh, that's with them. But you never got anything in writing from the other landlord / real estate company. Do you just automatically assume that your deposit went into their escrow account?
Okay, so the question was, if the landlord sells the property, what happens to your deposit? And the landlord sells your property, they're supposed to transfer that deposit to the other person. Hopefully, when you paid your deposit, you've got a receipt that says, I paid this deposit, and so when you're ready to move, you can say, I'm ready for my deposit back, the new company is gonna have to provide that, and then you'll be able to sue them for failure to give over your deposit if they wrongfully withheld it.
Thank you.
Yeah. Anybody else? Perfect, well, Kendra, are we gonna take a break?
Yeah, we are. Okay, so we're gonna take a quick break. Let's get back together about 11:30. We will adjust that agenda, since we are running late on time and we had really great questions already. We'll get rid of that last section. We'll get rid of the last section from 12 to 12:30. That's like the panel of all the speakers. So don't worry, we'll still get you out of here on time. So quick, see you back here at 11:30. started. Can everyone hear me? Okay. All right, perfect. So one thing that I forgot to say before we took a break, that at the table right here, there are some things from the City of Tulsa Working in Neighborhoods Department, which we have them here, back row, wave your hands. So a lot of the things that I'm going to talk about today that have to do with codes, both the Tulsa Health Department and the City of Tulsa Working in Neighborhoods can enforce those codes. Oh, we also have someone from County Code, right? He doesn't want to say. He's back there though. Okay, so we're going to have a lot of discussion about landlords and tenants and how the health department kind of is in the middle of that relationship. So anytime you have a question, just let me know and we'll discuss it. Okay. All right, so the reason that we're here today is because we've all been in that situation where we have lived without maybe water or electricity due to a storm or a water line break, and you can remember back to that situation and how stressful it was. You wondered like how you were going to feed your kids or give them baths or get them to school, or how much time you were going to be away from work. We have people in our community that live in that stress every single day. So that is where we come in, kind of in that landlord-tenant type situations, because I'm sure all of you will know we have those landlords that won't fix things that need to be taken care of. So we're there to help require them to get those things taken care of. We have parts of our county, the health department has looked at different neighborhoods that we know that the people that live in those parts of the county have a different life expectancy than in other parts of the county. It can be like 10 years difference, just depending on what neighborhood you live in. The environment that you live in, the house and the neighborhood, can greatly affect your living conditions, including stress on your life. Maybe different environmental factors can affect like asthma or different allergies. So that's kind of the space we're in. So we have several different laws that we use, several codes. So we have first the Title 24 nuisance code. That's a city ordinance. That's one that we work really closely with working in neighborhoods to get those high grass and weeds, trash, jumping, debris complaints taken care of. We also have Title 55, that's our property maintenance code. That's another one that we share with working in neighborhoods. So both of our departments work closely together to get those issues taken care of. So that's, the house itself or the apartment, inside or out. And then outside of the city limits, we have Title 63, and that's how we take care of county nuisances like high grass and weeds, trash, dumping debris, surfacing sewage, dilapidated structures. And then, unfortunately, outside of the city limits, if you live in the county, there is no housing code. We just have that Landlord-Tenant Act that Eric talked about. That's what we fall back on to, make sure that the houses are safe. One thing that we'll do outside of the city of Tulsa is if a tenant is having an issue, we can do a courtesy inspection and kind of send that notice to the owner to help speed up that process to get those violations taken care of. One thing that I want to note is that renting as is not legal in Oklahoma. So kind of what Eric was talking about, we need those basic necessities in the home. You can't say, we're renting this home without heat, and you know that going in. That's not legal. All right, so in the code, Title 55, it does give us the right to go into a home. One thing that we get a question a lot about is maybe a neighbor calls in on somebody and they want us to just go busting in and like tell them that, they're not cleaning their toilet correctly. So we don't do that. It's not allowed by law. But if a tenant invites us into their home to take a look around, or if we get a complaint and we have reasonable cause to go and do that inspection, this is where we get that right to do that. So again, working in neighborhoods from the Tulsa Health Department, or from the City of Tulsa and the Tulsa Health Department, Environmental Health Services is my department that I work in. We work closely to deal with different code violations all over the county. So we have really tried in the last couple of years to improve our processes and our forms to where we have the same document that we can work complaints with. The city mostly handles those nuisance complaints, like the high grass and weeds and trash, junk, and debris, and then the health department can help support them in whatever we need them to. The health department generally does inspections on the insides of houses, but whenever it comes to big things like large apartment complexes, both of our departments will work jointly together, because really they're just too complicated for one department to work on its own. One thing is, if you were ever going to call in a complaint on someone, you could always just call 311. We don't expect you to memorize our complicated relationship, but if you call 311, then they can explain to you which department you can talk to. So the things that we deal with at the Tulsa Health Department, Environmental Health Services, is we inspect those housing complaints anywhere in Tulsa County. So inside the city of Tulsa, we do have that Title 55 that we do inspections on, and outside of the city of Tulsa, we use the Landlord-Tenant Act. We do have the right to require that property owners repair things that are going wrong inside the home in that landlord-tenant situation. So some of the things that we work, things that we get phone calls about, we also inspect hotels and motels, swimming pools all over the county. We run nuisance complaints. We of course have our mosquito control program, so we're the ones that do the traps and the testing and drive the trucks around and spray with mosquitoes. We also have a rat abatement program. We have burn permits that we issue out in the county, so outside of the city limits, if you want to burn brush, you can call us and get a free permit to burn brush. We have asbestos removal permits. We'll talk about that later. We have a water quality lab, and then new coming to the Tulsa Health Department is a lead hazard removal program. So this is kind of how we work. We have the county broken up into different districts, and you can see that we're a pretty small department. We have different districts that people run everything from mosquitoes to housing complaints to nuisance complaints in. And so whenever you call in a complaint or you need to talk to somebody at the Tulsa Health Department, you're going to call in and talk to an actual person that's in our department. We really like to focus on customer service and answer your questions. And whenever we do get a complaint in, it comes in by phone or referral from another agency. We get a lot of online complaints, so you could always go to Tulsa Health Department. No, tulsa-health.org. That's so funny that I got that wrong. Tulsa-health.org, and you can submit a complaint online. We will take a look at that. The environmental specialist will take a look at the complaint and kind of decide how quickly to respond to it depending on the public health threat. We will take a look at past complaints on that property, and we like to look at the neighborhood as a whole to kind of see what's going on in that area and see what else we need to address. We will go out and do an inspection. We will call the landlord and the property owner. One thing I'm going to talk about towards the end of this is a program that we've come up with. We do like to call the property owner whenever we can to discuss what's going on before we start our investigation. Because you all know that there's two sides to every story, right? But a lot of times we don't have your phone number. Tenants don't have your phone number, or they don't want to give it up. So I'm going to talk about a program later that will help this right here. Us giving you a call and talking about what's happening before we just send orders. So here's some of the things that we investigate that have to do with housing and nuisance. We have high grass and weed complaints. We investigate bed bugs, people that don't have water. We take a look at those situations. Surfacing sewage is a big one. Mold. Mold is a complaint that people call in a lot to our office, and we're going to talk about that later. This is one that we don't necessarily have the ability to enforce mold standards, but we will take a look at what's happening and take care of the problem that's causing mold. So whenever we approach a house and we're investigating that complaint, of course, the first thing we look at is the exterior of the property, and this is kind of the stuff that we're looking at. High grass and weeds, if the windows are secure and the doors are shut, vacant, unsecure buildings. This is something that inside of the city of Tulsa, they're really good about. We will refer those properties over to them, and they secure those houses. I have a picture of a house that's secured later, so you'll have an idea. They keep track of those, and especially because they can become crime issues later. We take a look at the exterior of the house to make sure that there's no water damage or rotting wood. We take a look at like the stairs and the railings to make sure that they're secure. We like to educate people always about mosquitoes and stagnant pools. That's another program that we work really closely with Tulsa. We can larvicide stagnant pools, and then we can send them over to the city and they'll abate the problem inside the city of Tulsa. So whenever we get into the inside of the apartment or the home, we're taking a look at all the inside issues. So some of them are tenant related and some of them are homeowner related. So making sure that the place is sanitary, that there's no exposed lead-based paint. And one thing that we run into a lot, if you can see this picture, there's no doors. Like on the bathroom and the bedrooms, you're required to have an actual door, not like a sheet or a blanket hanging out. I don't know what happens to the doors on the insides of homes, but they are required to be there. So that's what is in here. Air conditioning, we get this question a lot. Of course, if air conditioning goes out while the tenant is living there, it needs to be repaired, and it needs to be like, what's the word I'm looking for, Grant? I always ask you. It needs to be similar. So if they have central heat and air and it goes out in like a 3-bedroom home, you can't just put in one window unit. That's not similar, okay? So whatever it is printed out, that's what it needs to continue on. And then one thing that Eric talked about a lot, normal wear and tear on carpet is not a violation. Okay, so here's an example of things that we might see. So a woman rented this house, and she is a nurse. She moved here from out of state. She didn't see it before she signed the lease. It was just over the phone, which to me is very dangerous. But I can see where some people, this might be something that happens. Whenever the woman moved into the home, there were lots of problems. Like the gas lines had been red tagged by O&G, so she didn't have any hot water, she didn't have any heat. You can see all the construction. Like that's the kitchen. Like, I'm not gonna push that button anymore. That is the kitchen, and there's no countertops. You know, like, right? And then in the bathroom, there's holes in the wall, and the light fixture's hanging. You can't really see it very well. That's what she moved into. And then, of course, the owner's like, yeah, we'll fix it. Yeah, we'll fix it. And then they sort of stopped talking. And then after a couple of months, this woman is like, I don't know what to do. She has a child. She's living in this home. She calls us. So what we do is we go out and we do an inspection. We try to make contact with the owner. This particular house had some condemnable violations, which we'll talk about. So then after a period of time was given for the owner to make the repairs, they didn't. She was able to leave without owing any additional money to the owner. So these are the types of things that we're looking at whenever we talk about housing violations. People living in houses that are completely unsafe. So here's an example of what those houses look like whenever the Working in Neighborhoods boards them up. They have the numbers and the dates, and then they monitor those properties, of course. So whenever we do our inspection, depending on the type of violation, we have different orders that we can send out. Like a notice of violation is for a nuisance complaint, like high grass, and then a order to repair and correct is for a housing complaint. And then if the housing complaint is severe enough, the violation, if it's a condemnable violation, we can send out an order to vacate. And so that helps the tenant get out of that lease. That's what the orders that Eric talked about whenever he goes to court. If they have that order to vacate, that helps the judge understand that this was a condemnable violation. We can also condemn a property once someone moves out if those violations haven't been corrected. I'll talk about those violations in a couple slides. That doesn't mean that the county or the city takes control of that property. It just means that no one can live there until those violations are corrected. I mean, sometimes it could be a half a day and it's taken care of, and sometimes it could be a year. It just depends. We do partner with the city, flagging the water meter. So we had a problem for a while of us condemning a home, and then the predator landlords would sit on the property for a while and then move someone in without them knowing that the violation existed. Like, let's say heat, it was condemned in the wintertime, but during the summer, no one's looking to see if the heat system was working. And then by the time the tenant moved in and got into the winter season, they realized it didn't have heat, and then the problem started all over again. So in that case, we now flag the meter at the city so that if a tenant tries to move into a property that has been condemned, a sign will pop up that says, call the health department or call working in neighborhoods because there are issues that need to be addressed before they can move in. I really think that that helps families that give everything they have towards a deposit, first and last month's rent, and they move into a place that eventually becomes unsafe. So how this works, and I had this question on break, if there's a complaint called in on a property, a notice is sent to both the tenant and the owner so that the tenant is not sitting on a violation and the owner never knows and is eventually penalized for that. So the time frame, of course, depends on the severity of the violation. It's generally 10 days is the lowest amount that I can go unless it's sewage. And of course, you can always call in and talk to the environmental specialist and kind of talk about what's happening in the house. So a good example that I'd like to use is like a leaky roof. So we all know how hard it is to track down the leak, get the roofing company out there. We think we have it repaired, but we have to wait for the next rain event to know for sure. So sometimes tenants have to live with a damaged interior ceiling because we're not going to have the owner go in and completely repair everything if we're not 100% sure that the roof is completely fixed. Does that make sense? And it can't be taken care of in 10 days. So you call the health department, talk to the environmental specialist, and just figure out what's best for each individual situation. So here's another example of an order to repair. The first page is all that legal, legal words. The second page is where you're gonna find the inspector's notes, like front bedroom had a window that wouldn't open, and weather strip missing from the front door, like the specific things that we say, not just the code talk. So here are the condemnable violations. These are the ones that we're most concerned about. If someone calls in with something like this, we're really going to stop what we're doing and respond. These are the ones that we would really like to have the owner's phone number so that we can get things taken care of as fast as possible. So, and then of course, this is what our condemnation notice looks like. It cannot be removed. You can't take it off and move someone into the property. There are penalties for doing that. So, no water. This is one that mostly the city of Tulsa, working in neighborhoods, they take care of these. You can't have people living in a house in the city without water service. It's very important for sanitation and personal hygiene reasons. And this is always fun. We find all kinds of fun things in water meters, like snakes. And this was a slip. It was like an attachment for a vacuum cleaner. So I'm pretty sure that would not have worked very well with the amount of pressure going through that slip. So these are the types of things you gotta look out for. All right, so surfacing sewage. So whether it's, bubbling up from the ground, dirty water coming out of the toilet, or just water from a washing machine dumping onto the ground because they didn't plumb it right. We take sewage complaints very seriously. It's a public health 101. Stop what you're doing and respond to the complaint. These are the shortest time frame that we'll use to get corrected, 48 hours. So we'll give 48 hours to get these complaints taken care of, or we can pull the meter. Now there's always those cases, of course, that you need to call your environmental specialist and talk to them about what's happening, and depending on the situation, we could adjust that time a little bit. So another big one that we focus on this time of year is making sure that we have safe heat in homes. So we want to make sure that all of the livable spaces are a minimum of 65 degrees or more. And we want to make sure that people understand space heater safety. They're not using space heaters as the only source. So if you rent a place that is central heat and air, and the heat goes out and it's December, the owner cannot say, I can't afford to fix it, here's a bunch of space heaters. That is not equal. We also educate people on not plugging space heaters into extension cords, making sure that they're keeping things away from the heat source. So here's different types of heaters that are not allowed as the sole heat source. So O&G will not allow those ventless heaters as the sole heat source. It can be like a secondary, supplement in a corner of the house that's a little bit chilly. We have lots of people that try to use stoves as a heat source. A lot of times we talk about this when there's been some type of a weather event, like the electricity's out and people are using their gas stoves. But just the other day, one of our environmental specialists was called out for a leaky roof, and then they walked in the kitchen and they were using their gas stove as their heat source. So it happens even when there's not some sort of a weather emergency. So whether it's an electric stove or a gas stove, it is never okay to use that as a heat source. Electric, of course, you can put a burden on that appliance and it can catch on fire. Carbon monoxide, you not only have that, but you have the risk, or gas stove, you not only have the risk of fire, but you have carbon monoxide that can be an issue. So electric and poor repair. This is where I like to talk about, I am not an electrician. So if I come out to a house and they're saying, I'm having these problems working my lights, and I see that, then I know to call in reinforcements. We're gonna say, we need an electrician to come out. We need to see the invoice that says the electrician has fixed this problem. Those codes change really often and I can't keep up with all the details, so I rely heavily on the professionals to let me know that that house is safe. Again, gas ventilation we look at, what's safe and unsafe for these units to be installed. Plumbing facilities, there are some plumbing violations that could be considered a condemnable violation, but something like a leaky faucet is not. So we handle those two different ways. We won't condemn a house on a leaky faucet, but we also want to remind everyone that the repairs need to be made with good workmanship. So cardboard box on a wall, duct tape end is not going to work as being repaired. All right, so how many of you all have heard my story about the outhouse in South Tulsa?
Oh my God.
Eric, it's his favorite story. Okay, good. So besides Eric and Brant, no one else has heard it, so I get to tell the whole thing. Okay, so this was it's an owner-occupied structure. The owner of a house, South Tulsa, very nice neighborhood. I wanted to live in this neighborhood at one point in my life. This wasn't the thing that changed my mind. It didn't work out. Okay, the owner passed away, and so the children lived in the house, and they were really struggling with keeping up with the repairs and the utilities, and they were sort of terrorizing the neighbors. It was a big thing, and I won't get into all the details, but eventually they moved on, and we were out at the house to make sure that they were gone so that we could have the city of Tulsa working in neighborhoods come out and secure the home. And this door was open and we were like, oh my goodness, so this is a shed that you would get at your local home improvement store, and there was a potty inside. They were using it like an outhouse. And this shed was no kidding 10 feet from the neighboring house. Like, this is a nice neighborhood. I'm sure they had no idea that there was an outhouse right next door. And it was just sort of a comical, situation. Not the craziest thing I've ever seen, but definitely noteworthy for a Housing 101 presentation 7 years later. And then the next day we went to make sure that the house was properly secured, and the shed was boarded with one of those boards, like the previous house. It has like the numbers and stuff on it. So then it was just kind of funny, because I think like someone's gonna buy this house at an auction, and they're gonna take that board off and it's gonna be an outhouse. Isn't that hilarious? It's one of my favorite stories. I almost took it out, but then I was like, no, I'll be telling this story in 20 years. All right, on to the next one, fire protection. This one's really serious. This is my thing, you all, smoke detectors. They need to be maintained. They're required to be furnished by the homeowner. Really, those batteries and all the maintenance that goes along with it, it needs to be maintained. Someone brought to my attention the other day, which I hadn't thought about, and I need to switch out smoke detectors in my own home. They have a life expectancy on them, so those also need to be switched out. None of us like turning on the news in the morning and hearing about a house fire and people losing their life because their smoke detectors were not working. So it is very important that we make sure that they're installed and working, and that people understand that if it's chirping, that means there's no battery and they need to get it repaired. So again, we also talk to people about the dangers of hoarding and how that can be important for them, their own safety, but also public or first responders that are coming to their house. We talk about proper use of heaters and extension cords. A couple more condemnable violations: unsafe equipment, that would be like an elevator; unsafe structure, the structure itself. So on to common violations. So these are things that we get calls about. Mold, again, like I said earlier, there are no regulations for mold. I can't do a test and go, yep, you got it, and you're out of here immediately. It doesn't work like that. So if we see something that looks like mold, we're going to try to take care of the moisture problem or the ventilation problem that's happening in that home, and then we'll educate people on the proper way to clean up mold. So roaches, mice, and rats, of course, they spread disease. We educate people on the proper way to get rid of them and how to keep them off your property, getting rid of the bird feed, getting the dog food in at night. All of these things are can attract rodents. Bed bugs, a lot of times it's really hard to determine where the bed bugs came from. So if it's an apartment complex and they're in the apartment, it could have come from a neighbor. But if it's in a house and it was rented pest-free, which is required to be rented pest-free, then it could be the tenant's responsibility because they could have brought them in, like bringing a couch that they found on the side of the road into their home. Or even, bed bugs can be anywhere. We could get them from different public areas and bring them home. So it's really hard to determine how that happens, but we like to look back at the lease and determine how long they've been there to decide who's responsible for treatment. Asbestos, of course, if you're doing work, especially in apartment complexes that were built before '81, there's different ways to approach the maintenance to protect the people that work for you so that they're not exposed to asbestos. Okay, so here's the fun part. This is our new program, Safe and Healthy Homes, because again, we recognize that there's lots of things that can happen in homes. Some of them are from the environment, the home, it's the owner's responsibility, but you can see that quite a few are the tenant's responsibility. And the things that can happen, the illnesses that can occur because of these environmental factors. So we created this Safe and Healthy Homes program. It's a free program. You have a flyer in your packet that talks about it. Right now we're in the pilot program stage of it. I have 1,000 units signed up, and it is basically, we can do inspections on your property, courtesy inspections that are free. We can help train the people that work for you on how to do these type of inspections. We also like to have your phone number, which would be part of it, so that if we ever did get a complaint, we could call you and discuss it before you just get certified mail. Another part is educating renters. So I'm sure that all of you have had situations where you're having really crazy conversations with people that you think should know better, right? So that is part of it too. It's not only talking to landlords about following the Landlord-Tenant Act and Fair Housing and Housing Code, it's also talking to renters about what their responsibility is. So that's what this program is. So again, right now we're in the pilot program. The main part of it is landlords and tenants using a walkthrough inspection form whenever, and you have a copy of this in your folder, before they sign the lease. And you're able to go through and say, heat is working, you have smoke detectors, there's no holes in the walls, whatever else, leaky faucets or whatever, everything is fine, right? So that if anything ever does go wrong and you end up in court, and this is kind of what Eric was talking about with having that paperwork that shows this is something that you could show. It has both of your signatures on it, the date, everyone signed up that everything was fine. You could show that there were no holes in the walls and your heat was working and you had smoke detectors. And that kind of puts it back on the tenant, the ones that are trying to take advantage and maybe get something out of you. Does that make sense? So this is the main part of our program, and then we have other things that we can offer, incentives-wise and courtesy inspections. One big part of this is, I'm trying to get back to that. This logo, we have stickers that you can put on windows, and we have certificates, and we have posters, and you can use this on social media, and eventually we'll have it on our website. Hopefully a goal is to have a searchable website so that people can go, who are the safe and healthy homes in Tulsa County? And then they can pull them up. So there's lots of other incentives. Another one is working with the city of Tulsa and working in neighborhoods, because they also have a texting system that they can use to let you know if there was an issue on one of the properties that you own. And if they have your phone number, they can send you information. If they don't have your phone number, they can't. So that's kind of a big part of what we're talking about here. Increasing that relationship with the property owner so that we can get things taken care of. So that's really it. We have lots of phone numbers. If you ever don't really know who to call, you could always call the health department and we could direct you. Another good resource for people, if you have tenants coming in and saying, I'm struggling with different issues, 211 is always a really great resource that you could refer them to. Any questions? None? Oh, one. Okay, good. I'm like, you guys are ready to get out of here if there's no questions. Yes.
So like the situation with the health department and the inspection and landlord education, that we're not putting out houses or what have you that have bad electrical plumbing, yada, yada, yada. And the tenants keeping up these nice houses. So there is provision as far as the health department speaking with these people to help them get the gist that they need to do something.
Yeah, I mean, the Tulsa Health Department, we are really focused on educating the public. I've already given out my card once to one person here today that they can invite us to come out to discuss things with people. One really hard thing for us to do is to get a hold of tenants, because they're not able to take off work to come to something like this. That's why we put it on Facebook Live, which you can also go to our Tulsa Health Department Facebook page, like it, and then you can share all of this information. We had our first Safe and Healthy Homes, kind of like a tenant education post last week about heat. You can share those posts. We will come and talk to people. If you have a problem and you need us to kind of mediate, the legal aid has mediation services, so does the city of Tulsa, but also the health department, and if you can help answer questions, that's what we're there for, is to get things taken care of. You know that sometimes the smallest little housing violation can set the relationship in a completely wrong direction for a long time. And it's expensive for you to have people move out. It's expensive for you to have to go in and paint and replace carpet and fix things. You want to keep people there, right? I want to keep people there. I want to keep people there so they're not moving their kids from school to school and dealing with the stress and the financial setback that can have. So I think we can all work together to try to keep them safe houses. Keep them in one place. Benefit the owner so they don't have extra expenses that they really don't need. Any other questions?
I have a quick question. You said that you help mediate for like bed bugs and rats. Is there any mediation for like infestation of like fleas or roaches or?
Well, I mean, roaches is one that we have, of course, roaches, mice, rats. well, any pest at all, a home has to be rented pest-free. Homes always have to be rented pest-free, so whether it's fleas, even if I don't have fleas up here, it counts. Trying to figure out who's responsible gets really complicated. Falling back on the leaves, talking to both parties, trying to figure out who is responsible. But we'll always be willing to talk to people and try to figure that out. Sometimes we have to refer to legal aid as well.
I think what I didn't understand about that was if you do move in, if you have someone that moves in with that problem, then what? So is
Okay,
that,
so it's handled just like any of the other violations. Okay, so the question was, I totally misunderstood. If someone moves into a home or apartment and there are pests, no matter what kind they are, they call us out and we send the notice of violation, and the owner has generally the 10 days to respond to get it exterminated. And then we just continue from there. Like, you could do enforcement on it. Most generally, owners respond and they get exterminated out there. Did I answer your question? Oh, okay. Yes.
What's a path house?
A path house. All right, that's a good question. Okay, so a path house is kind of a nickname for a house that has like a hoarding issue. So if you think about what you hear or maybe have seen, where they just have a path going through the home, those are labeled path houses. From what I understand, fire departments will label houses that they, path houses is for their protection. So if they respond to an emergency there, like a fire, we don't want to send firefighters into a home that is a situation that could be dangerous for them. So it's called a path house. Any other questions? Okay, I really appreciate everyone being here today. There are surveys in your folders. We really do appreciate if you guys fill those out. We take a look at them, we enter them into a thing, and a piece of paper pops out with all my information so that we can improve the next housing 101. Thank you for being so patient with our issues with the microphone. So I hope it got better after we got a good microphone that was working. And there are certificates on that back table, or you can pick one up from the line as you're walking out that you can use for continuing education credits. Again, there's information up here. Oh, I did forget to talk about the City of Tulsa hangers. These are really cool. So if you have a neighbor, or if you're an owner of a property and people aren't yards, you can always put them on their door. And it's like a nice, sweet, hey, did you move your car? And it looks really official and